it's done by industry standards. And so I'll just go over the issues that were outstanding, where I'd ask for some changes, additional data or clarification, and how we resolved that. So the first issue was crash data. In reporting the crash data, one of the things that they noted were that there were 4 incidents that resulted in head-on collisions, with no fatalities or injuries for those incidents. And just based on the fact that about 50% of head-on collisions result in injuries, often severe, I asked them to just verify that and provide backup. And they did provide me, for those 4 reports, they provided me the police reports and the narrative, and it did confirm that information that they said.
That there was no injuries at that point
That there
in
were-
time.
That there were, for the four noted head-on collisions, that those did not result in injuries.
That's not to say in the future someone did not complain of an injury.
There was no reported injury.
You're strictly relying on a police report.
That's the only way I would be able to verify anything, is what the police has noted, so. The second issue involved site distance. PAR reported that the minimum required site distance of 425 feet would be met if shrubbery and foliage along Line Rock Road was trimmed back at least 15 feet. Crossman requested backup diagrams showing that 425-foot sight line could be met with this trimming, and they did provide those graphics. Just a little bit of info, and if this is more info than you want, then I can move on. But site distance is the length of roadway ahead that's visible to the driver, and what we look at specifically for site distance is stopping site distance. And we look at that at the proposed, well, not we, they did, but as traffic engineers, what you do is you look at the sight lines, the stopping site distance at the proposed driveways to make sure where you're introducing a new intersection that it's safe. So a stopping site distance is the distance required by the vehicle traveling at or near the design speed of a roadway prior to reaching an object in its path. And in this instance, so basically, they're requiring a 425-foot stopping site distance. And the speed limit out there is 35 miles an hour. They did, they did a spot speed study, basically telling you for like 100 shots of cars, they were finding what the 85th percentile speed is. And that's kind of an important term that we use in traffic engineering. And it basically is the speed at or below which 85% of free-flowing vehicles are traveling. And we use that for traffic design, we use it for setting speed limits, and we use it for looking at what we need for sight lines. And so in this instance, if it was based on just the posted speed of 35 miles an hour, you'd need 250 feet. They're providing enough sight line for a 50-mile-an-hour driving. So that's, consistent with, it's actually a little bit higher than what the running speeds were. So. Right, so they provided that. The next issue that we had questions about was their trip generation and build conditions. We stated that there were some errors in the trip generation table 4 that should be corrected, and that the analysis for build conditions showed more trips than stated in that table. Crossman asked for the correction of the trip generation and an explanation correction for the analysis. And PAR, corrected the errors in the table and explained that some of the build data was from a previous iteration of this report that had been updated, and they updated that analysis for our review. And we found that to be acceptable. So this is the final, this was the 4th issue that we talked about with them, was traffic operation analysis. Sort of related to the last issue as well. Crossman noted that there were inconsistencies between the build analysis reports in the appendix and the results shown in table 6 and 7 that should be corrected. PAR updated the build analysis with the corrected trip generation. based on our previous comments, and they corrected the level of service table, which was consistent. So that kind of closed, they basically addressed the issues that we had noted as, needing more information or needing corrections on.
You were satisfied of the interaction and that those issues were resolved?
Yes.
Does any members of the board have any questions of the witness? Mr. Moon?
Yeah, 3-year period that was looked at for crash data. Is that standard?
3 or, I don't have that.
Page 8 of their original report at the top. Is that a standard? You're speaking with that? Time period.
It is it's 3 years is standard. I think there might be a new standard now to be looking at 5 years, but 3 to 5 years was the standard in the industry, yes.
I just happen to be looking through, it's an aside issue, but this board reviewed a report on safe roads in Smithfield, and I happened to notice that on that curve showed a fatality back in, I think it might have been 2019. That's, thank you.
Any other questions of the board? Mr. Resnick, any questions?
No question.
Thank you.
Okay, well said.
All set.
May I proceed?
Please.
Mr. Chairman, our next expert in the next discipline will be presenting is Moises Bobadilla. Moises is a professional engineer. He's an aviation expert on on or about December 16th. We provided your staff and your solicitor with a report from Mr. Bobadilla. That should be part of the record. I have copies, Mr. Chairman, if anybody would like that. The exhibits to that report include the site plan, include the aviation easement that was obtained by Rhode Island Airport Corporation in 2024 for this project. And in addition to that, Mr. Bobadilla's resume is attached. So I'd like to bring Mr. Bobadilla up so that I could have him list his credentials, his experience, and ultimately ask that the chair and the board recognize him as an expert. Mr. Chairman, would you like copies of this report?
I believe the report has been forwarded to all members of the board. If anyone is missing a report, please raise your hand. Okay.
May I approach?
Please.
Chairman, very, very briefly, before I matter over to my expert, I just wanted to discuss the aviation easement that I had made part of the package. So that's been made part of the record several times. It is an exhibit to this. And I would invite the board to take a look at it. So this is a aviation easement agreement that was entered into by Rhode Island Airport Corporation, as well as the owner of the property. And it's dated May of 2024. Now, I'll represent to the chairman that under Rhode Island law, state law, the Rhode Island Airport Corporation was created. And it was essentially created to ensure that federal requirements flowing from the FAA were enforced in Rhode Island and enforced by municipalities in the state of Rhode Island. And the act talks about two ways that that can be accomplished. One is through zoning. The other is for easements such as this. And in fact, the Rhode Island Airport Corporation, in May of 2024, as a result of updated FAA regulations and to ensure compliance, obtained this easement on this property. And I would suggest to the board that if the Rhode Island Airport Corporation believed that there were further restrictions that were required for this property in order to conform with FAA regulations, then they would have done so. And so what we have here, and I don't want to read this document verbatim, but we see that it is dealing with obstacle clearance surfaces. It's dealing with runway approaches. It's dealing with medium intensity approaches. It's dealing with the ability to remove trees, different types of vegetation. It's also part of this property, as you know, is a no-build zone as a result of this easement. So while my expert's going to discuss this easement, he's going to give the board more backdrop about how it works with the FAA and what was really being done here. I want this board to understand that Rhode Island Airport Corporation went around this state and they obtained easements from properties surrounding airports in order to ensure that FAA regulations were met and that anything that was needed to ensure that the surrounding area as well as the airport was in conformance and safe was done through this document.
Could I ask you a question about that?
Of course, Mr. Chairman.
When the easement was created, who was the actual owner of the property at the time?
The owner of the property at the time is the same owner of the property today, which is the First Church of God. My client has this property under control pursuant to agreement. We are here on behalf of the applicant, but there's in control through that. So when this easement was obtained by First Church of God, my client had that contractual right. So just so you understand, we had the right, we had it under contract. The owner, of course, was still First Church of God as it is now, and that easement was obtained by them. And they were paid. They were paid by the Rhode Island Airport Corporation relative to that easement. And the reason is this: there is only two ways pursuant to the Rhode Island Airport Corporation Act that we protect areas around an airport. We do it through zoning, or we do it through regulatory takings. And it essentially says that if an easement like this was obtained and not paid for, it would be a regulatory taking. And there's an entire statutory section in that act that discusses the rights of the municipality, rights of Rhode Island Airport Corporation, and the rights of an owner who where an easement has been taken like this and they've not received just compensation. So of course we didn't have an issue here because this was paid for. This was paid for by the state.
You're not saying that easement trumps the town of Smithfield, and in particular the planning board's ability to review, to make decisions, what's in the best interest of the citizens, and ensure that the particular project is in the best interest and safety of the citizens.
I am in no way saying that this document trumps that. That's why we're here this evening. We're going to hear a lot of testimony on that. My only point is that this is the tool, this is the mechanism where Rhode Island Airport Corporation, who is charged to do this federally, that corporation was created because of a federal act that required it. And our position is that Rhode Island Airport Corporation did what was necessary to protect the community and protect the airport and to conform with FAA regulations. So this is evidence that we believe is very important for the board to consider in making that determination. But it does not obviate or trump this board's ability to make findings of safety.
Right. For example, if a skyscraper was going to be built and installed in this particular land, irrespective of this easement, could run potential issues with health, safety, flight issues with the airport, et cetera, correct?
Oh, absolutely right. So all I'm stating is that we're not talking about a remote easement. We're not talking about something that happened a long time ago. It was a direct reaction to updated FAA regulations, and the Rhode Island Airport Corporation obtained this. And I had discussions with their attorney that drafted this agreement and negotiated with the First Church of God, and that was her task. Her task was to obtain these easements to ensure safety for communities. So I just ask that you consider it because it is extremely strong evidence. Thank you. And with that, sorry to be verbose, Mr. Bobadilla.
Going to have you state your name, your address, and want to swear you in, and then we'll begin.
Sure. Good evening, members of the board. My name is Moises Bobadilla. I'm a resident of Cambridge, Massachusetts. And,
Your address, your business address is fine.
275 Waverly Oaks, Suite 302, Waltham, Massachusetts.
You swear to tell the truth, the whole truth, and nothing but the truth.
I do. MOISES BOBADILLA.
And Mr. Bobadilla, could you very quickly go over your resume? If you could just share with the board your educational experience, any licensure you hold, including being a professional engineer, as well as any disciplines that you work in. And if you could provide some background about your experience in testifying before boards, courts, et cetera.
I'm a graduate of Virginia Tech. I got my bachelor's and master's from Virginia Tech. I graduated as a civil engineer. I've held that position. I've done that job for the past 10 years in both Virginia and Massachusetts, although my project experience spans all the way to the West Coast and out to the south of the United States. My experience within civil engineering is I specialize in aviation engineering. I'm an aviation engineer who does a lot of mostly runway and taxiway designs, as well as navigational aid development, navigational obstructions, design and development, and studies for both public and private development. I have in the past performed this kind of obstruction analysis and airspace analysis as well as the one who I had performed for this project.
Just briefly, Mr. Chairman, based off of that testimony, I ask that Mr. Bobadilla be recognized as an expert, and his expertise is an aviation engineer, PE.
May I ask some questions of the word that as a full idea before we do that?
Of course.
Could you tell us what in lay terms, what an aviation engineer is?
Sure. So what an aviation engineer entails is the design of whether it's runways, taxiways, apron pavements, essentially anything that an airplane touches as you land or depart an airport, as well as any green space within an airport. We look at federal regulations, especially for public airports, such as the airports within the Rhode Island Airport Corporation. We look at what the FAA says the regulations are, and my job is to interpret that and apply it to a specific piece of land, specific airport. Yeah.
Would it be the four corners of the airport?
It would be within what is the airport operating area or AOA fence, and as well as anything outside it, if it does pertain to airspace, navigational penetrations that would have an effect in safely flying in and out of the airport.
Have you previously testified under oath?
I have not.
This is the first time?
First time.
have you ever testified regarding the impact of an airport to abutting non-owned development?
Can you rephrase the question?
Sure. Have you ever given an opinion in your professional capacity as to the effect of an airport operation on abutting land to the airport where a private third party wanted to give development, undergo development regarding the development itself, not the airport?
I have.
How many times?
This would be my fourth time.
And can you tell me a little bit about the other three other experiences?
Sure. The other one was it was an addition to, an offsite addition to a hangar at an airport in Vermont. The other two included, development of a Carvana, I'll say,
What?
Carvana.
What is that?
It's like a tall tower where, cars are stored for sale. You essentially buy them off the internet and they go and pick them up from the just kind of store. So these are tall structures that have high likelihood of penetrating airspace. And I have reviewed and analyzed airspace implications for those buildings at two other airports. And
In any of those prior experiences you've had, were you required to take a look at Part 77 of federal regulations dealing with aviation?
that was the basis of my analysis, parsing the sound surfaces on top of any airport-specific approach and any other departures that they might have in place.
Questions, any other questions of the board? Simone?
For this experience in reviewing Part 77 surfaces, these were surfaces other than the RPZ?
Correct. This included primary, transitional, conical, the whole question. So
Go.
I have to, for what it pertains to my analysis.
Airports, right, go on to that. Structure, tree, road. Item. Like that. Possible.
Correct. It is my understanding, based on what's outlined on the agreements of the easement, that would be a requirement to clear any vegetation or otherwise obstacles in the path of any of the Part 77 surfaces, including building.
Any other questions? We'll certify the witness as an aviation engineer expert.
Thank you, Mr. Chairman. Ms. Bobadilla, I believe that you heard me reference a report that you submitted to this board dated December 16th, 2025. Familiar with that document? I am. All right. And in that document, you list your professional qualifications and the basis for your expertise, correct? Correct. And you, within this document, you perform an analysis of the airport overlay district compliance therewith, and you make professional findings in that regard in this document. Is that correct? All right. And you also make distance and site requirement findings in this document, correct? And you also make some commentary about operational safety benefits of vegetation management flowing from that aviation easement that we discussed, correct? All right. And you also as the chairman had asked, and one of the members of the board, you reviewed the aviation easement agreement, and you rendered some opinions on its consistency and compliance with FAA regulations. Is that correct? And ultimately, in this report, you render some conclusions, and I'm just going to read to you very briefly this summation in your conclusion. Based on my professional evaluation as a licensed civil engineer with extensive experience in aviation infrastructure and airfield safety, it is my opinion that the proposed development satisfies the town of Smithfield Airport Overlay District criteria, complies with applicable FAA regulations and Rhode Island law, meets all relevant distance and site requirements for safe landing and takeoff operations, and enhances operational safety by enabling the removal of vegetation that significantly exceeds the height of proposed structures. The project will operate under a reported aviation easement that preserves required navigable airspace protections. Have I read that correctly?
Yeah.
And Mr. Bobadilla, in order to come to the opinions and conclusions, did you review all pertinent federal law, including FAA regulations? Did you review all pertinent portions of the local ordinance, including the overlay ordinance? And have you reviewed the planning board's findings relative to these safety issues? And is it the materials, the opinions, your comments, and what you drafted in this report, are these being offered to a reasonable degree of certainty in your profession as an aviation engineer? All right. And with that, Mr. Bobadilla has a presentation, Mr. Chairman, that is going to go over this document. It's also going to provide some minutia, a little bit more granular information, so that the board has a greater understanding of the data and what Mr. Bobadilla analyzed to come to these opinions. And so I would ask that he be allowed to present, and I certainly have some follow-up questions, and I'm sure the board will as well. That's fine.
Okay. So my role in this project, and what I was tasked to do was to review and make sure that the proposed project does not, or analyze and see what was the effect on navigable airspace and whether the project posed a danger to both airspace and consequence to the public on the ground and the residents on the ground. The way I did that was reviewing both federal and local regulations. So that was in the part of the Part 77 surfaces. I also reviewed the existing instrument landing that exists on runway 5, which is the runway end that is closest to the development, as well as reviewing typical FAA approach vectors into runway 5 to see what the typical operation from a pilot's perspective, what the height of their landing and how that relates to a proposed project. And then I also, as mentioned, reviewed the easement to check for conformance with federal and local regulations. I'm going to start. So this slide right here shows the different airport hazard areas. They're A through D. Our project is shown in red, and that's the project site, which seen can lies within zones A, B, and C. What I do want to point out, and it might be hard to see for some of the audience, but there is a star kind of offset along the center line of the runway, and it's listed as, or it's labeled as runway 5 RNAV GPS decision point. So without getting too much into the weeds, runway 5 at North Central has two ways for pilots to come in. One is what's called a localizer approach, and the other one is a GPS approach. The GPS approach is what I based my analysis in for this specific part of my analysis, because it is the lowest, it prescribes the lowest elevation for a pilot to come in and land safely at the airport. The localizer approach is a much higher elevation and wouldn't be, the GPS would kind of be the worst case scenario. The GPS approach at runway 5 has what's called a decision point or decision height of 1.1 nautical miles from the runway 5 end. And what that decision point, what that really means is the FAA says if you're flying an airplane and you get to this point and you are at an elevation of 700 feet above mean sea level or below, if you're below that elevation, you have to abort and go around and try again, essentially. And it's called a decision point and go around point. So this is that yellow star that is shown on the screen, about 1.1 nautical miles along parallel to the center line of the runway. I also do want to note that that line, as it can be seen on the screen, is the project is offset to the south, I guess southeast of that line. In other words, the direct flight path from my pilot's perspective, as they go on final approach to runway 5, is not in the direct area of the proposed project. So I will show how this RNAV decision point and RNAV surface relates to the different Part 77s and different heights of the proposed project. But I do want to note, just in reference from a plan view, where it is to the proposed project. So on to Part 77 and obstruction surfaces. So the first one that I looked at, it's called the OCS, or obstacle clear surface. What this is a surface that has to be clear of obstacles so that pilots, when they're on final approach, they can't see the instruments that are going to help them guide and land safely on runway 5. This surface, as can be seen here in the shaded gray, is kind of the project area that penetrates from a plan view that surface, and this is the absolute lowest elevation in which there could be an obstruction. Clearly, I'm also showing the proposed buildings within the project area in a shaded blue, and there's a significant height between and difference of clear space between the OCS surface and the top of the potential top of elevation of building within that area. I am also showing in here the RNAV approach. I do want to keep in mind, I do want to note that, and let me go back to the previous slide. The elevations that I took for the OCS are the ground elevations close to buildings. If and the RNAV approach is essentially a projection onto that onto what those elevations would be. In other words, there's the line is not directly above it. So if anyone is flying on, if anyone lives in that blue house, their tail would be noisy, but there will be any aircraft flying right above their heads, essentially. But I did want to show it for context, and just to see kind of where everything lies and how everything lies together. The next one is the MALSEF line of sight surface. So runway 5 is equipped with medium intensity lighting surface. And what that does is just another way of guiding pilots. The reason why there's no buildings shown in this particular graphic is because based on where this lands, from a plan view perspective, there's no buildings proposed within that zone as far as line of sight. And the line of sight would just guarantee that a pilot can see the navigational aids that will help them land their aircraft safely. Excuse me. Now this is the Part 77 that the airport lies in. The first one is the approach surface. The approach surface is a 34-to-1 slope, 34-to-1 gradient from 200 feet away from the runway, and then it goes at a 34-to-1 slope up. What we can see here is, again, a projection of the runway 5 RNAV GPS approach line, and as well as the approach surface. Keep in mind, the approach surface is the bare minimum. The FAA says, anything below it has to be, there shall be no penetrations to it, essentially. Anything that's above it would be in violation of that. And this project, the buildings, the ground elevation, proposed building heights will clearly stay below it. And then the RNAV approach will certainly be a much higher elevation, although Bird mentioned again, it is a projection, as this particular project is not in the direct flight path. And then lastly, the transitional surface is a 7-to-1. It goes up at a 7-to-1 ratio, and the approximate location of the building height within the zone would clear the transitional surface in this case. So there would be no penetrations on the transitional surface of the Part 77 either. And this is just a map of kind of where these zones land. The Zone A is also known as the RPZ, or runway protection zone. As seen in here, there will be no proposed buildings within that zone, which goes in accordance with the regulations for that zone. Zone B, the approach zone, we discussed, and I showed how that line of the maximum proposed height would certainly stay below that approach zone slope or envelope. And then the transitional zone is that 7-to-1 slope, in which the proposed buildings will certainly be clear of any penetrations. And with that concludes, excuse me. And then the last part I looked at was the navigational easement, which I've already discussed, that the limits and the regulations set in that document by RIAC comply with the most current federal regulations in the way of Part 77, as well as line of sight concerns for existing navigational aids as part of runway 5. And it is my opinion that those are the most current and most applicable, and as well as this project, those stay within the bounds of those of the regulations set forth in that document.
Mr. Chairman, if I may, very briefly. Go ahead. Mr. Bobadilla, the testimony that you just offered to the board this evening, is that based off of a reasonable degree of certainty as an aviation engineer? It is. All right, and then I just have several follow-up questions for you. You are, in our discussions in your preparation for this matter, you are aware of the findings that are required to be made by this planning board at this master plan stage as it relates to safety. And I'm going to ask you, do you agree to a reasonable degree of certainty as an aviation engineer that the proposed development will not result in a significant negative impact on the health and safety of current or future residents?
I do.
And then during our discussions, your preparations, and the opinions you set forth in this matter, you did review section 9.2 of the town of Smithfield's Airport Overlay District. Is that correct?
I did.
All right. And there are 4 requirements in that overlay district, correct?
Yes.
All right. And the first one, subpart A, actually deals with the construction of a new airport. It indicates the area shall be sufficient to meet the Federal Aviation Administration requirements for the class of airport or heliport proposed, correct?
Yes.
And based off of your review of this airport, are you of the opinion that those items have been satisfied?
I am.
All right. And then the next part indicates there shall be no existing flight obstructions such as towers, chimneys, or other tall structures or natural obstructions outside the proposed airport which would fall within the approach zone to any of the proposed airport or heliport runways or landing strips. Do you agree that this proposed development does not create any of those issues?
I do.
And as it relates to the next item, it indicates there shall be sufficient distance between the end of each usable landing strip and the airport boundary to satisfy the requirements of the Federal Aviation Administration or any other appropriate authority. And I would ask you, is it your opinion that these distances that you've analyzed are sufficient?
Yes.
All right. And then finally, it indicates in cases where air rights or easements have been acquired from the owners of abutting properties in which approach zones fall, satisfactory evidence thereof shall be submitted with the application. And you would agree and you'd note that the aviation easement has been made part of the record and it has been the subject of your testimony, correct?
I do.
Right? And it's your opinion that that easement document effectuates the Rhode Island Airport Corporation's goal of complying with FAA safety regulations. Is that correct?
Correct.
And the opinions that you just set forth, are they to a reasonable degree of certainty, your expertise as an aviation engineer? Yes. Thank you. Mr. Chairman, my expert is ready for any questions the board may have. Thank you.
Mm-hmm.
Now that you've identified on this graphic, at what height would the plane landing be at that particular?
So at that particular location, roughly 1.1 nautical miles from the runway end, they would,
What height?
sure, it'd be at about 700 feet above
700.
means, yeah, above mean sea level.
Where you have the A, the center of the runway, what would be the height of the plane at that?
Don't know off the top of my head. But it would be,
Be less than 700 feet.
it would be less than 700, close to 400.
In fact, it would be probably closer to 300.
I would have to run the math on that, but it would be less than 700. Yeah.
So you didn't run any numbers as far as what height the planes would be over this particular area, other than the star that located or that you identified as a point of decision.
Correct. Yeah.
Number two, go to the graphic that you had with the showing.
I'm sorry.
Go to the graphic that shows the development.
Oh, sorry.
This graphic shows the development that is being proposed here, correct?
Correct.
Would you expect that street lighting would be present on that road that's between the units?
I would expect so, but I'd have to ask.
Excuse me, this is a little bit outside. I just want to make the record clear. It's 6-foot posts? Yeah, dark sky initiative, 6-foot posts. That's how I just want to make clear that, that's.
Well, he's testifying as an expert. I'm looking to get.
I understand, but I need to make sure that we're putting appropriate information on the record, and that's what it is. It's also, I just want to remind you, it is master plan.
It is what?
I just want to remind the board member, this is a master plan. So there are things with respect to lighting, et cetera, that could change at a point.
Right, but it also could affect, given the issue. Yeah.
So understood.
My question is this, you're testifying as an aviation expert.
Yes, sir.
Would the lighting along that road be distracted to the pilot who's landing that plane in that particular?
If it meets the requirements of the height requirements and it doesn't shine through the sky, then it does not pose per FAA regulations risk to flying.
So the conditions are, it has to meet certain other requirements in order for it not to be a distraction.
Correct.
Thank you. I just want to add very briefly that this is going to be dark sky compliant lighting. And we would agree to that, obviously, as a condition to this decision if we were to get a favor.
I have some initial questions. As part of your review, what material was provided?
I was provided the site plan in CAD format. I then reviewed publicly available documents. North Central has their airport layout plan, master plan publicly available, so I reviewed that. And then I reviewed the regulations, the federal regulations, but if I was provided by the client, it would be just the location of the development as well as the navigational easement had been reported.
What particular regulations were provided?
Sorry, if I misspoke if I said regulations are provided. I said I meant to say I reviewed regulations, like Part 77 regulations and federal.
And which regulation did you look at in forming your?
I looked at the Part 77 regulations.
Anything else other than Part 77?
And then the publicly available, approach surfaces on the ALP.
What's an ALP?
Sorry, airport layout plan. It's part of the airport's master plan. And that's where, the different slopes 34 to 1 and everything that I spoke to, that's where I used to make my model to show the lines and the graphs. And that's where I got the data from.
Any other documents provided to you by the applicant as part of your review material?
No.
You provided a copy of the master plan project narrative prepared by Joe Pasali Engineering as part of your review?
No.
Have you reviewed the master plan project narrative prepared by Joe Pasali?
I'm not sure I know what that document is.
What did you know about this particular development?
I knew it was a residential development.
what?
Residential development, being proposed, near North Central Airport.
What in particular about the residential, what type of residential development?
I really, mixed use, residential is,
How many units in what space? Any idea?
I have,
Without guessing?
I'm, I don't know the number of units off my head. I would lie to you.
You're generally familiar of different types of density developments?
Yes,
There could be low density, medium density, high density, correct?
I am, yes.
Do you know whether this was a low density, medium density, or high density project?
I am not aware of that.
Isn't that important information that's needed to form an opinion to determine whether this particular development is in violation of Part 77?
I know it's important for land use, but as far as Part 77, it strictly pertains to high penetrations of buildings or structures to specific envelopes.
Because our concern as the board is more with the land use, not so
Understood.
much the four corners of the airport.
Understood.
So is it fair to say then that your opinion in this particular case is not related to the land use of the abutment property, but to four corners of the function?
So my analysis and which formulated my opinion was that, no penetrations, no issues whatsoever in the airspace, right, and or within the airport. But that does translate, a safe airspace does translate to, in my opinion, to a safer ground. If aircraft staying clear of proposed buildings or structures, would, that therefore translates into less people being at risk.
And the higher the density development, more people are at risk potentially from catastrophic event.
I would agree with that.
That's what Part 77 tells us, correct?
It speaks to risk being, if a structure penetrates the Part 77 surface.
Tell me what Part 77 tells us about high density developments. Runway.
In RPZs, Part 77 says it's up to the community or the municipalities. It's up to it should be clear. It should be, the development should be should be avoided within those areas. But the RPZ in this area is Zone A, which technically the development, it is within Zone A, but as you can see up on the screen, there's no buildings proposed within Zone A.
Well, it also talks about zones A, B, and C, Part 77, correct?
Correct.
And that Part 77 says there should not be high residential development.
I wouldn't, I'm not certain that it speaks specifically to high density residential developments being prohibited.
You're not aware of that from the statute itself?
Mr. Chairman,
I'm asking, wait,
Mr. Chairman, I have the right to intervene. during
yeah,
an
and I have the
examination.
right to get an answer to my question, so
So
let him
after
finish.
this, I'd like an opportunity.
You can.
Sorry, can you restate your question?
In terms of zones A, B, and C under Part 77, is it not true that Part 77 talks about recommended, not recommended developments in those areas?
It speaks to some areas being more prohibited from development than others.
May I now?
You can, and then I had a follow-up question for that.
I would just ask if for my benefit, for the public's benefit, for the witness's benefit, and for your benefit,
that if we're gonna talk about particular portions of this federal regulation, I'd like to see what we're talking about. I'd like to see the actual language, because to be candid, I don't know if the way that you're quoting these materials is correct. I'm not suggesting they're not. I don't know if you're reading off of something. I don't have it in front of me. He doesn't have it in front of me. It would be nice to have the language that you're discussing in front of us.
Your experts testifying to Part 77 and, wait a minute, in its application to this particular project.
If the chairman does not have those
And-
materials available, fine. I'm just putting on the record that we would like
It's
to
not my,
see what
it's not
we're-
my obligation to have material fit for this particular hearing. In fact, Mr. Casali, in his report, he specifically references.
Understood. I put
So,
it,
so it's not like, it's not like it's a
Mr.
surprise.
Chairman, we're not gonna come to a resolution. I'm putting an objection on the record that to examine this witness on amorphous language that's not in front of us about portions of the regulations that you've not cited to. I'm putting an objection on the record. There's no reason to go back and forth. The objection's on the record.
I'm just testing your expert in terms of his knowledge of Part 77.
And I'm certainly not precluding him from answering the questions. I have the right to place an objection on the record. That's it.
Thank you.
Unfortunately, there's no judge here to rule, so that's where we're gonna be.
As the plan, please. As the chairman of the planning board, I will control how the meeting goes forward, okay? And certainly you can object, you can state issues. Your expert is testifying to certain facts, certain opinions regarding Part 77. And I, as well as other members of the board, would like to have a better knowledge of his working knowledge of that, so we could weigh the evidence. Whether we agree with the expert, disagree, agree with part of what he's saying, perhaps disagree with part of what he's saying.
And as I noted, I'm certainly not precluding that testimony, not trying to create a situation where the expert is not providing you with answers. The reality is that every time you ask a question, I have the right to lodge an objection. And unfortunately for all of us, we're not going to know the validity of that objection at this juncture. So all I'm asking, Mr. Chairman, is if I stand up after you've asked a question and I have an objection, I have a right to make it. That's it.
And you can make the objection. Let's talk a little bit more about what you did with respect to your analysis of Part 77 in relation to this project. What did you do to review, if at all, Part 77 to see if it applies and what applies to this particular project? Did you read a full copy of it?
I did.
And if you read the full copy, I assume you're comfortable with the inner workings in terms of the airport protection zones?
I through my experience, I've done work within to make sure stuff complies with airport protection zones. So I applied that same knowledge and made the same checks on this one.
So you didn't look at it purposely for this particular project? You were relying on prior experience from other projects?
No, I'm just saying I have prior knowledge that I use as a basis, and then I'll see how it applies specifically to this project.
Okay, and from your prior knowledge and your prior review of Part 77 as it pertains to runway protection zones, you're aware that within Part 77, it talks about different acceptable land uses for landing zone A, B, and C. And there's different categories. There could be commercial development, there could be low-density development, there can be recreational space, and of course, residential space. That's all indicated within Part 77 analysis of runway protection zones. Do you agree with that?
I think there's mention to those developments, although I will say Part 77 applies to any and all height, whether it's a flagpole or whether it's a carvana. So it applies to any of those.
And Part 77 is not there only for protection of the airport and pilots. It's also there to protect budding landowners, pedestrians, residents, etc.
Absolutely. It's put in place for the runway and runway ends, which in turn protect the land, adjoining land and butters.
And that's why there's recommended prohibitions of certain uses depending on what type of development for runway protection zones.
Correct. I think it speaks to putting it back on, the municipality to then, confirm whether specific land use is unapproved. Get in there.
And in terms of high density residential, could you tell me what Part 77 says about runway landing zones A, B, and C without guessing?
I am not aware of any specific requirements specific to high density residential.
You're not aware of any prohibition? Is that what you're telling us?
I am not aware. Other than, like I said, in zone A, it's way more prohibitive. But so yeah, that would be my knowledge of high residential or really in development, but specifically those kinds of development, residential development.
As part of your review of this particular project, did you come across the Rhode Island Airport Land Use Compatibility Guidebook?
I did.
Did you
find out.
review that?
Not in depth, but I did see it. I did see the map with the different colors and yes.
Well, it's actually a publication that's probably several hundred pages. Did you look at that document?
I'm not sure of whether it was 700 pages, but I did see.
Several hundred, not 700.
Oh, I'm sorry.
Yeah.
I did see a document that had the airport zone in it, that had land use map in it.
Right, but in terms of the written document regarding what is recommended, what's not recommended, did you review any of the written material?
I did see the different densities for the different land uses.
Okay. Are you aware whether or not within that particular document that you mentioned you did review, the Rhode Island Airport Land Use Compatibility Guidebook, whether or not it speaks to runway protection zones in terms of high density residential development?
I am not aware of that. No.
So you could not offer an opinion one way or another?
No.
But you would expect it would be consistent with Part 77, though?
Yes, I would expect to be.
Did you review of any Rhode Island general laws at all in terms of your review?
I did not.
The exhibit that we have up there right now, is this a document that you prepared?
No, it was not.
Who prepared this document?
I was prepared by the team. I'm not sure.
I'm happy to.
It would be helpful.
Mr. Casali, this was prepared by your team, correct? You would like to ask Mr. Casali what any questions about the document?
No. Other than when it was prepared. Before or after his testimony?
Before. Part of the original presentation.
There was another overlay that I think you went through showing proposed development.
This one.
Yeah. So the project site is red.
Correct.
In project site, correct, as portion of runway protection zone C, A, and B.
I just want to be clear, runway protection zone specifically speaks to zone A.
No, but this overlay,
Yeah.
right, it shows the project site touching upon portions of runway protection zone A, B, and C.
That's
Is
correct.
that true?
Yes.
Any other questions from other board members?
Did you review any documents provided by the Rhode Island Airport Corporation that took into account anything that is being proposed for this particular project?
I reviewed the easement. That's it. That's as far as the documents from RIAC, that is the length extent of it.
That's the easement.
That's what I reviewed. Yeah, I reviewed the easement.
Thank you.
Thank you.
Other questions of board members?
Are you familiar with US DOT Federal Aviation Administration advisory slip dated 9/16/2022, subject matter airport land use compatibility planning?
I am.
You are.
Yeah.
Thank you.
Any other member, any other question? Thank you, sir.
Chairman, a quick follow-up.
Sure.
Mr. Bobadilla, you just provided testimony based off of the board's questions, correct?
Yeah.
With the opinions that you offered to a reasonable degree of certainty as an aviation engineer.
Yes.
Mr. Chairman, that concludes our presentation of witnesses. Obviously, my witnesses are available for any questions that the community may have to the extent that we here in the board. There is one other item that I would like to discuss. I'm going to be very brief about it because there has been a written submission on it, but I just want to note it. I want to make sure it's part of the record.
Is that what you refer to as the motion that you sent in letter form?
I don't believe I sent a motion. There's a document, a letter that I sent to the staff, the board. My understanding from the plan of the burden is that it was made part of the record. It's dated November 12th, 2025, and it is labeled objection to enforcement of Smithfield Airport Overlay District, failure to provide legally sufficient mapping and notice. I just asked that, are you familiar with that document?
Yes, yes. So why don't we do this? Why don't we open this up to public comment? Take care of public comment. Then I'll let you go forward with your comments regarding that letter before there's any discussion of the application or vote.
My only concern, Mr. Chairman, is I do not want to go through this letter at length. However, on the screen right now, we have the overlay that we've been discussing. And candidly, I think that before this matter is opened up to the community, I really should put something on the record about this because I think that the community may have some questions.
We'll go with it.
And I'll be very short, and
Go ahead.
I can always follow up later if there's any questions. So, Mr. Chairman, as you noted in the testimony of our expert, we considered the planning board findings regarding safety, okay? We also considered the overlay, right? And that's because we wanted to make sure that we were addressing anything that was appropriate that the board was going to be basing their decisions on. And we believe that that testimony satisfies all of that criteria. That said, there is an issue with the town's overlay. It is a zoning overlay. It doesn't matter what kind of overlay it is. It could be a historic overlay. It could be a business center overlay. You could have all kinds of overlays, right? And it augments normal zoning, right? So you have your normal zoning, you have your normal zoning districts, and then you can create an overlay. The overlay, pursuant to our Constitution, that's my position, is that due process requires that the properties that are actually going to be in that overlay be delineated. They be delineated with either a list of plat and lot information that defines the properties that are in the overlay, or a zoning map, an official zoning map that would be on file with Town Hall that would designate this is the airport overlay and these are the properties within it. I will represent, Mr. Chairman, to the board and you, that does not exist. There is no.
It's in the comp plan, isn't it?
That is not, and we can discuss that. That is, in my opinion, and I'm not the determination, but I want to put my argument. You have this, overlay who is appended to your comp plan. Number one, that is not an appropriate way to create an overlay. Just because a document is at the end of a comp plan does not mean that you followed a statutory process. The only entity that can create an overlay is the town council. Usually it comes from the planning board for a report and recommendation, negative, positive, goes to the town council, and it's created. And it's not just created in a vacuum. There's serious notice that has to be required. In fact, any plat lot that is contained, any parcel that is contained in the area that would be subject to the overlay would require notice of it. So I'll give you an example. As a developer, I come to town and I want to know, what are the encumbrances on this property? What is the zoning? What are the dimensional? What are the use? What are the wetlands, right? A developer has the right to walk into town hall and say, I want to see all official zoning maps that designate what is in an overlay and what is not. And if a developer looked at this property, there would be absolutely no information that would suggest that this overlay would operate on it, because as a matter of law, it's not about where it is, we put it in the comp, we put it here. There is a specific statutory procedure for changing zoning in any way, shape, or form. It goes through the town council, has to be noticed in the papers for 3 consecutive weeks, and there has to be mailings to property owners that are going to be affected by it when it does not affect the entirety of the municipality, which we obviously have here.
Can I ask you a question?
Of course.
So are you telling me if ultimately we believe particular developer presents a risk to citizens, that we're to ignore that because of your argument? Is that what you're telling us?
I'm not suggesting that you're going to ignore it, because we've met it, but I have an obligation to understand, and I think this board has an obligation to understand, what is its jurisdictions, what are the required findings, what is the playing field, what are the rules, what are the
And
findings?
The other thing is I'm sure you realize that the board is really not looking at any zoning issues in the review of this particular application. We're looking at whether the application is meritorious under Rhode Island 4553-4.
So, and that's my question.
Because under the zoning, right, under our zoning regs, this project could not be built but for 4553-4 if it's met.
You're talking about the Comprehensive Permit Act.
Yes,
Absolutely.
right?
The Comprehensive Permit Act is state law. It supersedes. And, yeah.
But our zoning presently would not allow for your development, but for 45.
But that's not because of an airport issue. That's because
I
of
know,
zoning
we're
issue.
talking in generalities,
Right.
but we can agree. So this board is not looking at this application as being a zoning issue. We're looking at whether or not it meets the requirements under 4553-4, the comprehensive plan. And it has certain criteria. And one of the main criteria that this board has potential concerns with is health, safety of the residents, given the location of this proposed development, the size of this proposed development, the nature of the proposed development near runway protection zones A, B, and C. We're not relying per se on Federal Regulation Part 77. It's instructive, though, for this board as to what is potentially dangerous and what is not. So I just want to make sure you understand where we're coming from, so you can properly
And
advocate.
in fact, the reason why I asked to make this presentation was just that. Because when I sent this letter, it's not really my practice to read emails between lawyers and staff, but I will generally summarize that the response that I got from your planner was, we're not looking at the overlay. We're not making findings under the overlay. We're not doing that at all. So why are we talking about the overlay? We're just talking about findings on health and safety, as you just noted.
Right.
So,
But we
Mr.
can't ignore guidance and what's considered potentially dangerous or not.
So, Mr. Chairman, all I'm trying to establish is that the findings that this board needs to make are pursuant to the comp permit. And that what I understand the chairman saying is that we are not going to, we may look at the overlay. I'm not going to tell you what you consider in making those findings, but I do believe that I have the ability to ask, are you going to be making findings under the overlay? And it sounds like the answer is no. And if the answer is no, we don't have to talk about this anymore. But if the answer is yes, and I'm really not trying to make a show of this, but the community needs to know that there is an appropriate way to create an overlay. Happens all the time. Westerly has an airport. They have an overlay. If you look at the town hall, I went down there, you pulled the zoning map, you know every single plat and lot. It's not some document that doesn't have lot lines that shows an amorphous blob of an area in the back of a complaint. I am not suggesting that this board did anything wrong. I'm telling you, and I'm not suggesting that this town council did anything wrong, because I don't know historically when this actually was created. What I can tell you is that at some point, the town council created an overlay and they did not follow the appropriate procedure. And our position is, as a matter of law, that overlay is not worth the paper that it's written on, because it can't be applied to any property at all anywhere.
No, but your own experts have put forth.
Absolutely, because
Right.
I didn't know whether or not you're going to be considering it, and you're an attorney, I'm an attorney, you know what you do. Is that if you have a question about what is going to be applied, you cover it all, and we did cover it all. But I will suggest, and I say this in all earnest, that if this community obviously has a major concern about the safety around this airport, they should talk to their town council about creating an overlay that's actually enforceable and not in violation of our Constitution. And that's my position,
Although it's not germane to our analysis.
because you said you're not considering it, so it's done.
I didn't say that. I said we're not making a decision based upon any zoning. What we're looking at is whether this project complies with the comprehensive plan. That's it. Whether there's other issues such as, we look for guidance, testimony, from your experts, state regs, federal regs, the members of the public. We had 3 pilots that testified last time. We're taking all that information together, trying to sift through it and make a decision whether this particular project complies with the requirements. And that's our analysis.
And Mr. Chairman, I think,
Because like I said, purely under zoning, this project's not allowed but for the compact.
that's a very general statement.
It is,
Without the Comp Permit Act, this particular project would not be before this board.
That's correct.
That's correct.
Because it
And
would
I-
only allow a
I-
low density.
I would say that your due diligence, this board's due diligence, your concerns, the examination, I'm not objecting to any of it. That's what we're here. We are here about safety. But a lawyer and an applicant, like any member of a community, has a right to know what is the law or what are the regulations that operate on the property. And I'm just going to say one thing, and then I really am done with this, unless the chairman has more questions. In being a land use attorney who has gone around the state and developed a lot of different kind of projects and dealt with all kinds of different overlays, I have never seen an overlay that is codified that was done in such an inappropriate procedural manner. And I'm not saying that you have anything to do with it, but this town needs to know and the community needs to know that this overlay doesn't really exist. That's my position. I'm not the arbiter of it. I have to make the argument. So I am concerned about that because we've talked a lot about this overlay.
Like us to send this back to the town council for their action overlay and all the matter in high side for the next 2 or 3 years while they work on putting that overlay together?
No, because I'm not sure. No. Why can't there's a lot of clapping and banter. Could you repeat that? I didn't hear it. I don't know. I mean, I'd like to hear the question or the statement.
Would you like us to send this back to the town council?
No, you don't have any authority to send anything anywhere. You have an application before you for a vote.
I'm not talking about your application. I'm talking about the issue with the overlay.
I don't know what you're gonna do. I'm just putting on the record that there's a problem. You can disagree with it, you can agree with it. It's just my legal position, and let me tell you, it's very well researched. And I provided an a very verbose brief about it, a lot of citation. I'm not gonna sit here and do pinpoint citation unless you want me to. I'd be happy to do that. I can cite the cases right now. I'm ready to rock.
But Mr. Chair, I just had one comment about that legal opinion from Attorney Resnick. If his opinion, legal argument is correct, and the overlay did not exist, which is irrelevant from your findings you have to make from the planning side, I think the law would then do what it's done in other situations where if there was something enabled from the state level that the town or a locality was supposed to do that didn't do yet, you would still revert back to the state law as what would be in effect. The state law regarding this overlay district under Title I specifically incorporates Regulation 77 and says there's these airport hazard zones. So I think even if the finding was there's no overlay district, I think state law would still govern this board on the overlay.
Yeah, again, I don't think that there's any reason to get into that thing. All I'm suggesting is I have a reason and the board has a reason to protect this record. And we need to understand how the decisions are being made, why they're being made, and what findings are gonna be made. And I leave it to the board and the chair as to what impact this overlay is gonna have on their decision. Whether you're influenced by it, whether you consider it, whether you bake it into the findings that you make under the Comp Permit Act, I don't have the right to tell you that. But what I can tell you is this is really not about what state law says other than this. State law says that if you are gonna change a zoning ordinance, you have to do it appropriately. And when it's an overlay, you need to notice it, you need to notice the property owners, and here's the real item. You have to delineate the parcels. If there's no plat and lot data and there is no map that shows the lots and the lot lines, you have a problem. And it's not just on GIS. In fact, what's on GIS doesn't matter. We all use GIS, doesn't matter. Can't rely on it. There's only one thing that you can rely on. What is at the town of Smithfield? And unless I miss something, I think you and I both know there is no plat or lot information like that, and there is no map. That's it. I have to put that on the record because I could tell you what could happen here is you could consider the overlay. And we could be back here really quick on a remand. That doesn't benefit this town and it doesn't benefit this applicant. It doesn't benefit anybody. We want a decision, whether it's good or bad for my client, to be clean so that when we go up on an appeal, we have an appropriate appeal that can be decided by the court and not come back here. So that's why I had to put it on the record. I could go on and on about overlays, but
We got your argument.
thank you.
What we're going to do is we're going to take a 10-minute recess, then we're going to have public comment at approximately 7:45 or thereabouts.
Thank you.
Darren?
No, I know. It's now 7:44. We're going to open the matter up for public comment. Anyone that would like to be heard, please come forward. There's a microphone in front of me. If you could state your name, your address, and I'll swear you in.
Good evening. Matthew Fague, F-A-G-U-E.
You swear to tell the truth, the whole truth, and nothing but the truth?
I do, sir. First, I'd like to thank the board for your diligence on doing all the research that you have, not so much just on the aviation part of it, but the research and all. I'm going back to, you go back to the comprehensive plan itself, and you look at the proposed residential area. Again, Boston did their job on the peer review. The lighting in the area, the lack of sidewalks in the area. I think there might be a bus stop over near the coffee shop. The infrastructure that's supposed to be in that place to make this viable for people that live there, where these people are gonna walk through. So that's a safety issue. There's no medical facilities in the immediate area. There's no banking. I don't know if people are gonna be allowed to walk across Route 7 to go up toward Voorhees. There might be a lab up there where you can have blood work done. But in the immediate area of this project, that infrastructure isn't there. And then to talk about the infrastructure, the sewage, we can go back to that, not to rehash it, but the pump station up at Whipple Hill and Route 7 is gonna need some type of work. And again, it's gonna fall back on the taxpayers. As far as the crash data, Mr. Mullen was talking about a possible fatality on that road in 2019. Anytime there's a fatality in any of the towns, it's the police's obligation, and if they don't do it, the DOT from downtown will call and say, hey, you guys haven't filled out a FOS report. Federal accident reduction. They want to know how the accident happened, why the fatality was caused. I didn't hear Crossman say, hey, we looked at FOS data and said there were no fatalities out there. A lot of this data takes 2 or 3 years to come to record when it's put out by NHTSA, so you don't see it right away, maybe 2 years in the rear. If you do a quick check down, you put in 2019 fatalities, on that road, you're gonna get data that's only up to date to like 17 and 18. It's like prorated by the time they look at statistics. They looked at the 85 percentile, 50 miles an hour on that road. The curvature, the lack of lighting, the downhill slope, whether it's uphill or downhill, the entrances to the residents. When you look at 50 miles an hour, that's highway speeds. So I'm surprised there hasn't been worse accidents out there. And again, at 50 miles an hour, you might need about 175 feet to come to a safe stop. That's if you use normal reaction times, normal distances, not talking about fog, water on the roadways, ice, and we know that area gets like that a lot. As far as the airport, there's pilots in here that are probably more proficient at testimony about that airport. I'm not slighting the aeronautical engineer. He didn't say he was a pilot. I've flown out of this airport. I got a cousin that's a pilot. I used to fly out of this airport in little Cessna 152s, 172s. That same cousin learned to fly out of that airport, now flies professional corporate jets. If you look at the type of air traffic that come in and out of that airport, it's not just the local pilots. These are jets that are coming in from New York, Pennsylvania, points south. You have, it's kind of like a roundabout. They don't want to be at Warwick. They can land there. They can get in a car and then they go to points north. A lot of athletic people land there, go up to Foxborough. You have the golfers that come in, go up to Boston for the Opens. Brian's going to be hosting possibly teams for the big soccer coming up. They'll probably be using that airport as a drop-off for these people that are coming and going from other countries for this World Cup. It's an uncontrolled airport. So it's not always lit, it's not always occupied. That glide scope, if I'm correct, looking at that star behind Mr. D'Ambra, that is the landing approach. And I'm sure some of the pilots in here can attest to that. I believe the runway's built up about 50 feet from maybe mean ground level. That glide slope, the housing that's built into that, and these type of jets that are landing there, those jets are loaded with jet fuel. It's not a small Piper airplane that, yeah, it does run off of aviation fuel. But coming in on a glide scope, if something was to overshoot the airport, doesn't go around, comes in again, doesn't come in appropriately, and lands or crashes in that residential area, that's gonna be a bad crash. Not to use the term napalm, but that's the type of crashes that happen in these facilities. He didn't talk about studying the safety of crashes recently or anytime in the last 5 or 10 years with its high density around these type of airports. It might seem small, might seem like a little local airport, the amount of traffic and the residents in here can attest to, it's not just small airplanes. There's a lot of jets going in and out of there at all hours, a lot of helicopter traffic. Made some notes, I'm just trying to keep it, I want to keep it short. And again, just getting back to the roadway, there's distracted driving, weather conditions that can change that 400 or 450-foot sight picture and reduce it dramatically. Inexperienced drivers. So again, I didn't hear anything on the FARs to confirm whether Mr. Mullen was right. I know he does his research, I'm not doubting that. But I would think that the traffic engineer would say, hey, I looked at the FARs, there's nothing been reported there for the last 5 or 10 years. Thank you.
Thank you. You can state your name, your address, and then I'll swear you. And Mark Clark. Swear to tell the truth, the whole truth, nothing but the truth. I get it. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Thank you for allowing me to speak. I'm also the owner of Legal Primary Care and a 20-year resident. This is the reason why I moved to this town, and still a pretty good community. And I don't see the
There you
proposal
go.
moving in this direction. My daily trips to and from work, also in Smithfield, take me on that section of Line Rock every single day. So over 20 years, I'd say those two trips per day and my recreation trips on that same road are probably thereabouts in the number of 10,000. I would submit that that makes me subject matter expert on that strip of road, what's going on that road. I suspect there's a few more subject matter experts on that road. I'm also a subject matter expert in medicine, which has no bearing here. And I'm a subject matter expert in common sense. And I think most of the people in this room can clearly see by listening to the comments of the board that everything out there. Okay. That being said, I don't know what your charter is. I would infer that your charter is, and it was said by the chairman, that you're here for the safety and the betterment of the citizens of the local cause. Getting back to the road, I'm sure we're all familiar with it. There are two pieces of foot traffic on that road right now. There's a gentleman who lives in the White House that's kind of sitting out in that field for public transportation, so he has to get to Route 7. He can walk in that a little bit. And there is what appears to be a monk from the temple that takes walks in that road as well. And that's it. These are grown men. They have the whereabouts of grown men, and I can see the look in their eye as the traffic's coming by. These guys are ready to die when they have to. Over those 10,000 trips up and down that road. There's been many occasions where I crossed paths with a tall or a larger vehicle, and I physically had to stop because one of those gentlemen was on that road. And they were probably going to hit, and we would see the guys were ready to jump. Okay, so what we've got right now is that's our foot traffic. You put this development there, and that's not gonna be our foot traffic. It's gonna be a lot more pedestrians, including probably children on and off the bikes. Children wanting to just get out of their neighborhood and go to the next neighborhood. I think that's an unacceptable safety risk. Don't think anybody on the board would sleep well finding a 7-year-old child that had to get fuel off the front of the bumper of the car because we allowed this development to happen. We also have to consider the potential impact of an already overburdened school system. When experts at IM meetings testifying that, of course, there would be no such thing happening, and I don't really agree with that testimony. I think with that many housing units, there's going to be quite a bit of strain put on the school system that's there. My common sense reads that this is a bad idea. For reasons I've listed into many. Back on the matter of subject matter expert, I think we all know in any topic or any venue, you can purchase a subject matter expert of any kind. You can get the subject matter presented in a fashion that's going to support your case. Sometimes if you spend the right money, you're going to get a really good one. Sometimes if you don't, you're going to get one rather mediocre, and I believe that probably rings true with lawyers as well. It's what you pay. So basically, the legal representation and subject matter experts in mind, very often this type of situation becomes a contest of who has the deeper pockets. The city of Smithfield, the board, whoever authorizes our purchases, or the prospective developer. And I don't know exactly how deep his pockets are, but I imagine that they're not that shallow. So we're going to have to ask ourselves, who would be the major beneficiary of this project? Would it be the citizens of Smithfield, which I think you all represent and you feel in the heart of hearts if that's what you're here for? Or would it be a former resident of Smithfield who lives in the town, who is now a record developer who would like to get a bit wealthier on the backs of this project without really having any great heartbreak about what it might do to our town? We all know what the site looks like. I'm sure that some of you drive on that area fairly often, maybe not as often as me, but it's a lot of tight, winding roads. There's no sidewalks, no paved sidewalks. It's dangerous. It just doesn't belong. Okay, if I'm going to fall back into the theme of common sense, it doesn't make common sense to authorize this civil project to go forward. So what I would ask of the board and the chairman is that when you make your decision going forward on this, this decision is made clearly on what the right thing to do is, what the common sense thing to do is, and more important, what the right thing for the citizens of Smithfield. I think if you make your decision based on that, you're going to make a decision that doesn't. Thank you for your time.
Very briefly, Mr. Chairman, I would just object to the representation that this gentleman's an expert in any various categories that he had identified. And I would also ask, I can only ask this, can't compel it, that there be some decorum and not be personal attacks on my team who is here presenting an application that they have the right to do. But I can't command it, I can just ask for it.
I appreciate it. I got to say, for the most part, the public has been very appropriate with presentation, not interrupting. It wasn't a per se personal attack, it was more of a matter of economics. Witnesses. testifying.
Understood.
He didn't offer to be an expert area. He's a concerned citizen. There's commonplace knowledge of probably 10,000. We take that as all.
Yeah, understood. And I agree with you. I think the decorum over the several meetings that we've had has been very good. But candidly, I can see the temperature. We got a long night tonight. And I just think it would benefit everybody to have respect for professionals that are doing their job.
I can guarantee you, if I think they're going too far afield, I will not allow that, just like I.
I'll be in the back row then.
Last
Thank you.
3 sessions.
Thank you.
Thank you.
I
If you can state your name.
Kevin
your
Buthelet, Lime
address,
Rock Road,
And you swear to tell the truth, the whole truth, and nothing but the truth?
so help me God.
Go ahead.
I can say that, right?
Yes.
First thing, which wasn't really part of my notes, but after listening to the expert tonight, one thing that was not taken into consideration, okay, is human error. I think it's like 99% of plane crashes, small plane crashes, is pilot error. And this wasn't discussed at all. This is a training airport. I've lived here all my life. I've seen what goes on this airport, and there's a lot of, well, I'll get into that. But I've been in the area since 1960s. In that time, I witnessed many plane accidents, first starting in 1969. And this is only the ones that I can remember, okay? Number one, what is now West Farm Road, single engine, 3 casualties. Number 2, Harris Road, single engine, into the trees. Number 3, Nado's Farm, now Blackbird Farm, single engine, in between 2 barns, 1 casualty. Number 4, North Central, twin engine, 1 casualty. North Central Skydiver plane, 6 casualties. Off Clark Road, now Blackbird Farm, single engine, 2 casualties. North Central, twin engine, overran the runway. North Central, 2 planes landed together, one on top of the other. Number 9, which was the latest, single engine into the pond on Lime Rock Road. So this is just the accidents that I can remember. There might have some that I omitted. At this rate, it's a crash about every 6 years on average. You gotta remember, still, it's a training airport. And the interesting thing about all these accidents, they all happened within a quarter of a mile of the airport, all right inside the zone. That's about all I've got. Again, just take this all into consideration. I appreciate all your time and effort. Again, I don't think it's a matter of, if there's another accident, it's a matter of when and where it's gonna happen. Thank you.
Frank Ritchie, 14 Carrion Drive.
Swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
I am a student pilot, and I've flown quite a few times in and out of the airport. Someone said, well, student pilots aren't good. You're darn right. We are not good. We make mistakes. One of the first things we have to do is control our altitude. It's very difficult to control your altitude when you're starting. A little pull this way, a little push that way, and all of a sudden you're diving, you're coming up. And to keep it there, it takes a lot of practice. So that's just some of what we have to go through, other than stalls, when we actually have to stop the plane and it falls, and we have to recover from that. Fortunately, we have a very good instructors that are with us, and there have been times where I get so much overloaded with so much information from flying. I say, you have to take the controls. He takes the controls, and I acknowledge it, and he lands the plane for me. Another incident that just happened 2 weeks ago, Greg Biffle landed 1,800 feet before the runway in a jet. It was a big fireball. Now, he landed 1,800 feet. There may have been another 500 feet prior to that where he was below, maybe 50, 80 feet high, taking out everything that was in his path. That's what we're looking at here. So you're a half a mile from the runway where Greg Biffle took out all of the shrubbery, took out everything. Fortunately, there was nothing there. He wound up landing on the runway. Unfortunately, 7 people passed away from that accident. That was just 2 weeks ago. The other thing I want to bring up is the walking down Lime Rock. I went to Davies Vocational and I was one of the first people that were going there for a few years. And we didn't have good bus transportation. I'd have to walk all the way down Lime Rock, all the way down to 7 to catch my bus. And I did that many times, the whole entire year, and even in the winter time. Mom couldn't take me, so I had to walk. And I'm telling you, I dove out of the way a bunch of times just to not get hit. The only way that's gonna work, you gotta open it up, you gotta put the sidewalks on there, and the state has to approve because that's a state road. Thank you very much.
Hello, Marcus Pacheco, 11 Redfern Drive, Smithfield, Rhode Island. Absolutely, I did. So, I'd like to point out that the subject matter expert from the FAA today did not address the subject of crashes. I think the board did a great job of pointing that out today. And I'd like to point out that, you know, a certain accusation was made a few moments ago about the temperature in the room and the decorum of the people here. And while it may be true that the people here are upset, I would like to remind the board that the supreme law of the land, and I wouldn't rank myself as a subject matter expert on the law, but I've read a document called the Constitution, kind of says the state is forbidden from imposing restrictions on people's free speech. So if people want to voice their upset or concern about this case, you kind of don't have the power to stop them. And any attempt to stop them would be deeply illegal and a First Amendment
I
violation.
disagree.
We have rules of decorum, and you certainly couldn't make threats
Okay.
or engage in fighting words.
Let me finish. For the most part.
Are you attempting to stop me from talking now?
No, I'm just giving you a comment. This board controls this.
Of course you do.
Okay?
Yeah.
And we'd appreciate this meeting continue, that the
I'm-
existing decorum
I'm
continue.
sure you would appreciate it. It would be great if that was in your power. It's just, it isn't,
Well,
frankly, and it's not in their power.
we have
And if
a po-
people want to come here and they want to, you know,
We're not going to go there.
have some
We're
comments,
not going to.
I'm gonna go there right now. And you can drag me out of here if you want. I'll be happy to make the civil rights case happen after. It'd be great.
You do
The
have-
Church of Mammon here followed their own rules that are laid out in the book that they claim to follow. They would not prioritize money over their neighbors, and they would not prioritize.
I'm not a member of that church.
That's fine, he represents them. The Church of Mammon here, if they would prioritize their neighbors over money, would not be having this problem. They would just develop in the area the way that we've laid out the rules for. And as far as this overlay goes, it's mentioned in your deed on the property. It's not new news. It's in all of our deeds if you live in the area. And it shouldn't shock anybody. And it's not the board's fault that the state changed the laws after the regulations were established that made it like a 2-acre zoning in that area. So I just wanted to point all that out before we get too deep in the weeds on stuff. And if people want to voice their concerns, they're more than welcome to. You guys all have the power to do that. Thank you. Nobody can stop you. Have a great day, guys.
Diana Garcia, 55 Maureen Drive, Smithfield.
You swear to tell the truth, the whole truth, and nothing but the truth.
So help me God. I'm here today to talk about the white elephant in the room, which no one kind of dares to talk about, but I feel like it's very much in the back burner of all of our minds. There seems to be an epidemic of phantom poverty in the United States, which does not correlate with the decline of poverty that our great country is known for. Every year, somewhere in this country, there has been some format of new legislation for more affordable housing, some kind of infrastructure, or different means of transportation. I'm 39 years old. 37 years of my life have been spent trying to buy a home. I've worked countless hours of overtime, countless 60-plus hour shifts during a week, countless pickups on shifts and on calls, and I can guarantee what I've had to put down on my home for a payment was a lot more than the initial cost of it. And I feel like that can be said for all of my neighbors.
Hillside Estates, where I reside, was established in the late 1970s, less than half a century ago. What's changed? Legislation, countless legislation. Since welfare and public housing began in the 1960s, 179 million people lived in the United States. Less than 4 million people at that time applied for welfare. Where are those numbers today? There's currently 379 million people in the United States, and over 250 million people had a grievance that there was a pause in their SNAP benefits during the recent government shutdown. I'm not a fool. I find it very hard to believe that more than 2/3 of this country, a superpower, a land of the free, a land of free choice, a country enriched with countless field job opportunities, cannot find the means to obtain food, housing, and nourishment for a majority of its population. Every single year, this country has more legislation that not only gets introduced but passed by government, grants for money and subsidies for what's blanketed as those in need. I find it hard to believe that someone making less than $100,000 a year is in complete dire need. I know that as a fact because I was one of them. Where am I today? I'm in a self-bought home. It's human nature to want more when given more. Comfort breeds content. Content breeds carelessness, and carelessness breeds crime. One of the reasons why I love my neighborhood is because many people are just like myself. We've crawled out of less than comfortable and sometimes even dire situations to make a name and a life for ourselves. Bare knuckles and all, we are the backbone of America. And I don't take that phrase lightly. These legislations for those in need have led us dry. We have higher taxes, higher food costs, and minimal disposable income. It's safe to say this new affordable housing regulations and welfare have broken us. It's also crowded what we once thought was a quiet home, threatens a stable neighborhood, and a piece of what we used to call the American dream. For the record, I would like to be noted that I do not agree nor support any legislation that requires some affordable housing to be placed in any new bill. It's time for America to pick up its pieces and work together, not for one another. I believe members of this builders have insulted our intelligence. I believe you forgot that Smithfield has all professional and apprehensive people. We all pay attention to detail and politics, and we all care. And I believe that you have forgotten that no one likes to leave this neighborhood. A lot of my neighbors are original tenants. Rhode Islanders do not like to leave Rhode Island. We don't forget our past because we've worked very hard to crawl out of it. We all have earned our homes. And I think I speak for a majority of this room when I say that this backbone has been broken. Thank you.
Hi, I'm Ross McCurdy, 10 Meadowview Drive, Smithfield, and I'll try to keep this short. Yes. Mr. Odell, you had a question earlier about that star there by B and what the altitude above ground was. One of the altitudes might have given was above sea level. Above ground altitude for that star for decision altitude would be 271 feet above the ground. So I just wanted to point that out. So significantly lower than 700 feet above MSL because the field elevation of North Central State Airport is about 442 feet above sea level. So I just want to help answer that question. I've got a question for the aviation engineer. Are you a pilot? Okay, not a pilot. Okay.
The questions you gotta pose to the board, and
Okay.
then we'll have them.
Fair enough. Thank you. Also, looking at the red for the project site, that is really close to the approach end of runway 5. I mean, that's pretty clear to see. This map is a big help there. I also want to point out runway 5 is the southern one there, and a lot of airplanes are coming in there. But the traffic pattern, so they fly a big rectangle around the runway, all the pilots, and runway 23 is the one at the top. The traffic pattern is a left traffic pattern, so they're going to be flying pretty much directly overhead of that project site. That's going to be the flight path for what they call downwind for runway 23. So student pilots and any other pilot practicing approaches, they're going to be doing rectangles and flying above there repeatedly, pretty much every time they fly. I just wanted to point that out. And I think that concludes my questions or my comments. And
You previously testified. What's your background?
yes, I'm a pilot, not career pilot. I'm a high school science teacher over Pontiac, but I've been flying for 20 years. I'm an instrument rated pilot and a commercial pilot, and I fly out of North Central State Airport. I'm in a flying club there, so I fly out of there very frequently.
Thank you.
And I also want to thank the other pilots who've been here as well, who are able to give some insight as they actually use the airfield. And thank you for listening to everybody and doing your best to make the best decision for the people of Smithfield.
State the name of your address, I'll wait.
David Negri, Nigri, 14 Forestwood Drive.
Should I tell the truth, whole truth, and nothing but the truth?
I do. First of all, I'd like to thank you for giving me the opportunity to speak at this hearing. I'm respectfully highlighting, based on my opinion, potentially safety considerations as related to aircraft noise levels when considering a multi-unit residential complex located approximately 7/10 of a mile from the approach end of runway 5 at North Central State Airport. As previously mentioned by one of my neighbors, runway 5 and runway 23 are the primary runways for jet operations. As a professional aviation person and a user of North Central State Airport and a resident of Smithfield, I am concerned with compatibility and coexistence between high-density residential developments within the proximity to GA airports. I will comment on this particular overlay here in a minute, but in order to do that, I'd just like to give you my background. 46 years as a civilian pilot, director of operations for North Central Airways back in the day in the 1990s, if you remember. First officer for 2 major airlines, 28 years corporate flight experience, flying business jets and turbine helicopters in and out of here. 16 years as director of operations for Textron. As an adjunct professor, which I currently am, I teach aviation safety management for undergraduate at the local universities. I have my certificates include airline transport pilot, certificated flight instructor for both airplanes and helicopters. I have a master's degree in aeronautical science from Emory-Riddle. I've served on multiple safety boards, including international safety boards for business aircraft operations. With regard to the overlay here, as was just mentioned, I've done numerous approaches into North Central State, specifically for runway 5. It was mentioned specifically about the STAR, which is 1.1 nautical miles away. When you look at these approaches that are going in there and you have an RNAV GPS approach, that particular approach has multiple approaches embedded in it. If you were to take a look at it, you would actually see that you have 4 approaches into that with that one diagram. With that being said, it was mentioned a little while ago about the LPV approach that goes down to approximately 271 feet AGL. With that being said, the STAR that's pointed out there is what you call a VDP. It's a vertical descent point. If you're doing a non-precision approach into this particular airport, when you hit that VDP, the aircraft should be stabilized and you should be able to make a descent, a normal descent going into the airport. At that VDP, if you have not seen the airport environment, you will continue to fly at your altitude to the missed approach point, which is at the end of the runway, and then you will execute a missed approach. I've flown many jets in and out of here. Do you see a big blue and white jet? If you've seen that lately over the past couple of years, I was probably manning a jet. The noise signature, and I've flown helicopters in and out of here as well. The noise signature of a jet landing is more than you would get on a takeoff. As an example, you may have a noise signature, and we do this all the time, especially flying into Europe, that we have to have these noise signatures already available. You may have a dB level of 87 or 89 on departure. Coming into this airport, you could see with the starting your descent at the STAR, at the visual descent point, that's not the missed approach point, it's at the VDP. At that particular point, with your aircraft configured for landing, you could probably, you would see 90, 91 to 93, I'm giving you an average,
of a dB level as you start to descend, right over that new overlay where you're looking at right now. On a helicopter, you could see if it's a turbine helicopter, you might see 93 dB decibels on the approach on average. And I'll talk about some noise here in a minute, other noise considerations. The average single engine light aircraft is approximately 73, I would say. And when you get into the newer aircraft, single engine land, you're looking at about 83 dB. About 2 years ago, significant, and I'll mention what the airport is, Rocky Mountain Metropolitan Airport. The airport is approximately 20 miles west of Denver International, just to give you an idea of where we are. About 2 years ago, significant noise complaints from residents in a development next to an airport within a mile came to the public eye. Similar to this current situation, warnings about safety and noise issues were made clear to the town. But despite those warnings, the development was approved anyway. With increased traffic in that airport over time, noise became intolerable to the residents. In an article that was written, and it was provided by the AOPA, combining the high and increased number of training operations occurring at the airport with regularity of touch-and-go operation leads to an unreasonable amount of noise and lead particles exposure over the town in Boulder County. During the summer, piston engine aircraft touch-and-go operations begin before dawn and continue nonstop throughout the day. Noise data shows that a single touch-and-go operation can be more than 1,000 times louder than ambient noise level measured on an A-weighted decibel level. Due to the constant impacts of these operations, residents at this development have stated they cannot open their windows, they cannot use outdoor spaces, and cannot sleep without interruption. Again, before the development was approved, the town was warned about noise issues with residential development being put so close to an airport, but the town still went forward and allowed the development to take place. Now, there is an active legal case on behalf of the towns against the airport. In fact, the case will be heard. It was heard once, and because of the way it was disposed, it's going to be heard in February 11th, 2026. Residents of this Lime Rock development would be exposed to constant loud noise, and similar challenges could arise. Because of the proximity to the airport, land where the proposed development would go, in my opinion, is incompatible. The issue in Colorado is a good indicator of what could happen here. That airport had existed for decades before the residential development was proposed, and concerns about incompatibility issues were raised to the town, as well as the likelihood of noise complaints. Responding to the residents' numerous complaints about negative impacts to their quality of life, the Aircraft Owners and Pilots Association regional manager made this statement. This all could have been entirely avoided had the town chosen to heed the many concerns expressed over the years about risks of placing residential units in close proximity to the airport. He continued to say, "It is the local communities who suffer when political subdivisions make zoning and development decisions that ignore warnings and extensive guidance regarding compatibility land use near airports, and instead prioritize anticipated property tax revenue from residential developments over the quiet enjoyment rights of their future community members." That was the statement from AOPA. Numerous concerns have been raised to this board, including noise issues, as I just did, and incompatibility land uses. it is only reasonable that putting a residential development just 7/10 of a mile from runway 5, which is runway 5 and 2-3, predominantly used all day if a jet is going in there. You don't have the landing distance on runway 3-3, 1-5 for anything maybe than a light jet, even if that. With that being said, is expected to see, and I'm going to list this here and I'll give you this number, at least 52,000 takeoff and landings by 2027 will impact the lives and residents who live there. But this can all be prevented. In the master plan from RIAC lists what they have there is 3 levels of development for North Central Airways. The 3 levels, they have a low, medium, and high. I'm just going to focus on the high because I don't have the other document. I don't have the document in front of me right now. With that being said, currently there is estimated, actually a couple of years ago, 27,000 takeoff and landings per year. Based on RIAC's forecast and based on their extrapolating out to 2027, RIAC is saying 52,000 plus takeoff and landings, which we call operations, is forecast to take place here. I'll even go one step further because you may or may not know it. If you look on the RIAC website specifically for North Central State Airport, they are advertising to bring in developers or to bring in individuals to build hangars and increase the aviation population at this airport. I would take that respectfully, I would ask that you think about that. Think about what the impact would be based on what I've just mentioned regarding aircraft noise with a multi-unit development 0.7 miles away from the approach end of runway 5, which is a predominantly jet runway. Now, the other aircraft use it, but if you're flying a jet, you're using that runway or runway 2-3. Thank you very much for your time. Thank you.
Good evening. Michael Villiard, 11 Clock Road, Smithfield. I swear to tell the truth, the whole truth.
Swear to tell the truth, the whole truth, nothing but the truth.
No, no, she said. Villiard, V as in Victor, Illiard. I'll keep it brief. I just want to comment on the safety and the overall quality of life that this has an effect on. By no means am I claiming to be an expert. However, on my 33rd year of law enforcement, I've seen a lot of traffic patterns. I've seen vehicles, and we've lived at our address over 20 years. I've seen the traffic pattern of our neighborhood. When we first moved there, it was basically a 3-way intersection at the intersection of Karen Ann Road and Clock Drive. On Clock Road and Karen Ann Drive. It was basically a dead end at the end of Clock Road. They went ahead and they proposed a development, which we thought was going to have an egress on Angel Road going into Lincoln. That never happened. So that whole development now has come down Clock Road and basically turned that into a very high 4-way intersection. So it went from a mediocre, dangerous 3-way intersection to a heavily populated 4-way intersection. What we're talking about is the same thing at Clock Road in Lime Rock and Karen Ann Drive at Lime Rock. It's a 3-way intersection. They're going to be converting that to a 4-way intersection. That is very dangerous. I can speak for my neighborhood. I see people that actually live on Karen Ann Drive. If they decide to go down Lime Rock Road towards Route 7, they don't go to Karen Ann Drive and try to take that left onto Lime Rock Road. They come down the Clock Road, they exit through Clock Road because it's safer and they can see around that corner much more clearly. In inclement weather, it's almost impossible to come out of Karen Ann Drive as vehicles are coming down there. I would think that with an intersection coming out of that development and crossing over the most dangerous part of that road, and that would be the vehicles coming down the hill in inclement weather, there's no way that those vehicles would be able to stop. Currently, the vehicles that are coming out of Karen Ann Drive, they typically take a right to go up towards Lincoln. If they're gonna take a left, they exit through Clark Road. So the vehicles pulling out of that new development would be crossing the most dangerous part of that road. And now I'd like to discuss the aftermath of what happens after they do put that development. So since they put that development in, we've seen numerous times where there was potential accidents, people blowing their horns at the intersection of Karen Ann Drive and Clark Road. I've asked for the stop signs to be transported into those lighted stop signs that are operated by solar panels so that they can say that they obviously seen the stop signs. They couldn't install those. I asked for speed bumps at the intersection. I said, even if they were removable speed bumps, I would take ownership and remove those speed bumps during the plowing season and put them back in the springtime so that they would be there for the remainder of the year. They told me that was the biggest obstacle with the speed bumps is that they couldn't put those in there because of the plows. I've asked for a no outlet sign to be placed on the other end of Clark Road because numerous times if there was a traffic delay on Lime Rock Road and they diverted traffic into our neighborhood, they took a left onto Clark Road and kept going down, figuring out there was no egress, and they would all come back the opposite way. Now they're pissed off and they're blowing right through the stop sign. So I asked for a no outlet sign to be posted there just so that people would be aware that if they went into that neighborhood, there's no way for them to get out, that they would basically have to take a right to go down Clark Road. So my point is, after they develop these developments, it's almost impossible now when you see the aftermath of the traffic problems to get that corrected because I've asked numerous times for these things and they've never been implemented. As far as the quality of life, when they built those developments, the constant noise of these 10-wheeler trucks carrying loam, gravel, stone, whatever you want to call it, it made such a noise that my wife was working from home and she would constantly have to interrupt their conversation and apologize because the noise level was so loud. And we're talking about at least 3 trucks an hour constantly for 8 to 10 hour day. So 25 trucks a day of just brr, brr. There's a monastery right up the hill. Their quality of life will be greatly affected by all these trucks. Not to mention, when the trucks came down, they didn't stop at that stop sign. They did a rolling stop through Clark Road and continued down Clark Road. If that happens on Lime Rock Road, that's going to be potential for big problems. And they're going to have to stop because they're going to be taking a left into that development or a right coming down the hill from that hill. And they're going to stop the traffic on Lime Rock Road. Because if there's a car coming down, if they're coming up the hill and they're trying to take a left into this new development, they're basically going to have to stop. And those cars coming down are not going to stop for those trucks. So it's going to back that traffic all the way down. But it also increases the traffic for our neighborhood. People that are cutting across there and they're going to, say, Mineral Spring Avenue in North Providence, they're not going to go down Lime Rock Road and take a left on Route 7. They're going to cut straight across. They're going to cut through Maureen Drive, and they're going to come out on Route 7 that way. It's going to increase the amount of traffic that's already in this neighborhood due to the new development that take place at the end of Clark Road. A school population, we were very fortunate when me and my wife lived there, that when our children went to that school, they had learning disabilities, and the teaching to student ratio was such in proportion that the students were able to get benefits from having teachers that were able to cater to somebody that might have had a learning disability, or somebody might have, like, say, an organizational skills. If you increase the population of that school, there's not going to be that ability anymore because the students are going to outnumber the amount of teachers that are going to be able to perform those duties. That's all. Thank you for your time.
Hi, my name is Olivia Ruthven, R-U-T-H-V as in Victor, E-N. I live in Oregon right now, but my permanent residence is 9 Price Lane in Smithfield. I do. I'm here as a concerned member of the public, but I am also a licensed attorney and wanted to speak just a few comments about expert witnesses. During the October 23rd meeting, this board expressed concerns about the safety of residents who would live in this development because of its location so close to the airport. In response, the applicant's attorney said that he would retain an aeronautical expert witness who we heard from this evening. As you know, expert witnesses are here to help you understand complex evidence and information to help you make the most informed decision. Your concern and the purpose of this expert witness was to address safety of future residents at the development. Experts should be trained, have the appropriate training, education, and read through all of the relevant material. As we heard tonight, he's a professional engineer and you qualified him as an aviation expert. It didn't sound like he read the Rhode Island Airport Land Use Compatibility Guidebook, which seems pretty relevant to this particular issue. He also said tonight that his background is mostly runway and taxiway designs, not relevant to the safety of nearby residents. Briefly, his opinions in the report and what we heard tonight include that the development meets site and distance requirements, that it would clear, so the development would facilitate clearing of some tall trees that could be an obstacle in the flight path, and that through the aviation easement agreement, the Rhode Island Airport Corporation did secure the necessary rights to be in compliance with the FAA regulations, which to my knowledge was not something that was at issue. It is also, once again, completely irrelevant to the safety of future residents. He also said in his report that the proposed development is consistent with FAA regulations regarding compatible land use. Yet in published documentation, like Member Moan mentioned tonight, the advisory circular, the FAA specifically says that residential use near airports should limit the allowable density and discourages development of multifamily residential units. That doesn't sound like the FAA would say that this high-density residential development is a compatible land use, like Mr. Boveda claims. It sounds like the opposite. His conclusion in the report is a broad statement saying that the proposed development complies with federal regulations and Rhode Island state law. So tonight, when asked by you, he said he did not review any state law. So his conclusion does not carry much merit. Also, applying facts to the law is not easy, as many of you are attorneys. Attorneys and judges struggle applying facts to law. So I would contend that as an engineer, he is not qualified to conclude that this development complies with federal and state law. But for argument's sake, even if he could, Chair Yambra said at the October 23rd meeting, the board doesn't care whether it does or does not comply with law. What you care about is the land that you have jurisdiction over. This particular land in Smithfield and the safety of potential future residents. You accepted him as the expert, but you can still decide how credible you find his testimony. And regardless, he does not state in his conclusion or anywhere in his report or state tonight that he believes in his professional opinion that this location would be safe. He emphasizes that the development is not directly in that flight path on that graphic there, that it's a little to the southeast. As pilots have mentioned tonight, that does not account for human error. It does not account for the touch and go path that occurs regularly. I grew up in the neighborhood just southeast of that. Planes fly over my house constantly. Plane accidents occur in that, like they said, is pilot error, mechanical error, things that you don't account for. This is assuming a perfect ideal scenario. The attorney this evening also talked about the overlay district and how it's not accurate. That doesn't change the fact that this development would be so close to the airport. That distance doesn't change regardless of how it is done. Tonight, the expert was asked if he agreed that there would be no significant negative impacts to the health and safety of current and future residents. Required finding number 4 of the Comprehensive Act. He says it won't have a negative impact. But what is he basing that on? We didn't talk about safety or health of residents. We talked about flight paths, trajectories, nothing to do with safety. In conclusion, like I said, this board was very clear about what your main concern is, the health and safety of those residents. And the applicant has failed to demonstrate that this location is safe. No one, not even experts, can assure you that a residential development in airport hazard zones, especially B and C, the approach and transitional zones, is safe. Because frankly, it's not. The FAA and Rhode Island Airport Land Use Compatibility Guidebook both say that residential developments in these hazard zones should be precluded to limit the number of people put at risk. And further, that having open land use increases the chance that if pilot needs to make an emergency landing, they have the space to do it. Aircraft accidents happen. Like I said, pilot error, mechanical failure, or otherwise. And most of them statistically happen right near airport from takeoff and landing. Those accidents are out of the board's control. How this land is developed and whether or not a high number of people are put into harm's way is within your control. Please keep the current and future residents safe of Smithfield by denying this application. Thank you.
State your name and address, please.
Peter Parsekian, 18 Cross Street, Smithfield. I did. We haven't done the math here. There's 140 units proposed, correct? Roughly 140. If 70 of those owners daily drive out of this complex and back again, that's 140 trips, additional trips daily on our highways in Smithfield, going to Dave's, Home Depot, Putnam Pike, restaurants, CVS, libraries. Every day, 140 additional cars on the road. 70 out if half of those people that own these condos drive in a particular day, and half back. So that's 140 vehicles a day. You multiply that times 365 days, you're talking about over 50,000 additional trips on our roads in Smithfield. Is that what you want as a planning board? 50,000 additional vehicles on our road in a year. I don't have much more to say than that. I live in an area where there's a lot of traffic. It seems to be getting worse, but I want you to think about that 140 units and that 50,000 additional vehicles in a period of a year. And I think those are accurate numbers. So, thank you.
Good evening, Tom Hodgkins, 200 Farnham Pike.
We swear you in. You swear to tell the people the whole truth, nothing but the
I do, so help me God. I wanted to start off by addressing the record, and I hope the board will address the record tonight too, and identify what's in the record. There was a letter from the applicant's attorney, November 12th of 2025, that was referenced earlier tonight. I made several requests to the planning department in 2025 and earlier this week in 2026 for all materials that were submitted by the applicant. I did not receive that. I don't know what else I haven't received. It's not right that this board has materials to consider that the public hasn't been provided. And my ability to respond to that application and everybody else's ability to respond to that application, the materials that have been submitted, is severely prejudiced by not having those materials in advance of tonight to be able to address those with this board. So I hope before the end of the hearing tonight that you will make clear exactly what is in the record for the determination of this decision. I wanted to address first the issue that was brought up at the end of the applicant's presentation on the overlay district. The applicant's counsel suggested that everybody in this room needed an education about the zoning ordinance in this town. Counsel, I don't need an education about the zoning ordinance in this town or the comprehensive land use plan.
I don't think anybody else in this room does. We've all participated in the development and adoption of those plans, and we know them well. And that's why everybody's here tonight, because high-density development does not belong on Lime Rock Road. So I think we're all set with that. Thank you.
Try to address your comments to the board, please.
Well, I will, Mr. Chair, but that comment by the applicant's counsel is directly addressed to the audience about whether or not they needed an education. So I think we should have a chance to respond to it. The applicant wanted to address the overlay district. The overlay district is essentially irrelevant to the board's determination with regard to the runway protection zone, which is established by state law and federal law, Part 77. And more so, I would draw this board's attention to Rhode Island General Laws, Title I, Chapter 3, Section 13, which is titled Conflict with General Zoning Regulations, which states in the event of conflict between any airport zoning regulation adopted under this chapter and any other regulation applicable to the same area, whether the conflict is with respect to the height of structure of the trees, the use of the land, or any other matter, and whether those regulations were adopted by the political subdivision, that the airport zoning regulations, or by some other political subdivision, the more stringent limitation or requirement shall govern. The more stringent limitation or requirement here is what's established by federal law and what's established by Part 77 with the runway protection zones there, which prohibit high density development in those landing zones. So whether the overlay district applies or not, state law is clear that it supersedes whatever the restrictions are in the overlay district. With respect to the expert report, there was previously provided to me a report that I understand was submitted by the applicant from an individual named Joe Santo, dated November 25th of 2025. Is that part of the record that this board is considering?
It is, but the witness was wrong.
How was that witness withdrawn? Was that in writing to the board?
No, the last.
Okay. I just wanted to be clear whether that was something else in the record. I would ask this board to ask the expert witness whether he reviewed this November 25th, 2025 report by Mr. Santo. Because I know this board has looked at these two reports. They're nearly verbatim, word for word. So I'd ask the board to ask the witness who wrote his December 16th, 2025 report, given that the report a month earlier by a different expert is nearly verbatim. I will attempt to add on to the very good argument that was made earlier on the expert witness. I would ask the board to supplement its voir dire of the expert witness on a couple matters. From what was put into the record, and if there's any dispute on it from the applicant, from what was put into the record, there was no record of any expert, of the expert's education or experience on Rhode Island law, any application of Rhode Island law, or any professional experience with Rhode Island law. There was also no record with regards to any bodies in Rhode Island where this expert has been testified to qualify. So apparently Smithfield would be the first. Further, there was no record made with any experience that the witness had with applying any zoning ordinances. So if there's any, I would just ask the board to clarify those issues. I would also ask the board with regards to the expert witness report, page 2 on the airport overlay district compliance professional findings, the second sentence states the project provides adequate area to meet FAA requirements for the applicable airport classification, demonstrates the absence or appropriate mitigation of flight obstruction. That's an important distinction that this board needs to know. Is this expert's opinion that there is an absence of flight obstructions, or is this expert's opinion that there's appropriate mitigation of the flight obstruction? That's an important distinction that this board needs to know, and to know what the expert's opinion on that is. I suspect that the way it's written here is that there are flight obstruction. Because if there weren't flight obstructions, the expert would have written, there are no flight obstructions. But that's not what's written in the report. What's written in the report is demonstrates the absence or appropriate mitigation of flight obstruction. I did not hear in the expert's testimony what the appropriate mitigation of flight obstructions were and what the flight obstructions were. You need identification of those flight obstructions to be able to weigh that opinion. I would also draw the board's attention to the conclusion in the expert report, the following paragraph, that the requirements are enforced and interpreted through the town's airport overlay district standards. As I said before, Rhode Island state law mandates that the stricter limitation applies, and that would be Part 77 and the runway protection zone. Just for a minute to comment on the parking analysis. What's been presented to you is an analysis of the traffic analysis. What's been presented to you is an analysis based on an assumption that these will be single-family detached or single-family attached type residencies in this development. What hasn't been presented to you is what the traffic impact would be from different uses of those of this development. And it's just as likely that this development, the market rate units, could be used for other uses. It's just as likely that someone would buy those and rent those out, or that they could be used for short-term rentals. These could be Airbnbs, if that's what the owner chose to do. And if those uses were put into place, such as rentals for student housing, there's going to be a much different number in population of vehicles. It's likely that you'd have at least one person per bedroom and at least one car per person living in each of those bedrooms, which is going to be a significantly higher traffic count. That's what's been presented to you. And the applicant hasn't provided you any other analysis if those uses were put into place. Very generally, I know this board knows that the Rhode Island Airport Land Use Compatibility Guidebook is incorporated into Smithfield's Comprehensive Community Plan. The Comprehensive Community Plan mandates that the Rhode Island Airport Land Use Compatibility Guideline is consulted with regards to developments. The Comprehensive Plan also incorporates Part 77 in those runway zones that the expert was not familiar with. As the board knows, those runway zones limit or advise against high-density development and congregations of people within those zones. That is the determination that this board is bound to. That determination that what's behind you in those airport runway hazard zones, that there should not be high development there, that's already been determined by federal and state law. It's already been determined by Part 77. This board doesn't need to make that determination that there shouldn't be high density development there because of the threat from the aircraft. Once this board makes a determination, which it seemed undisputed, that this development falls within the runway protection zone, the denial of the application is mandatory under the application of Part 77 and state law. So I suggest you follow those. We have in Smithfield still some rights to have a say in what happens with development in this town, despite the state law attempts to take away our control of local zoning. We still have some rights to do that. Health and safety is one of them. And for those reasons, I suggest that you deny the application. Thank you.
Good evening. My name is Alan, A-L-A-N, Ruthven, R-U-T-H-V-E-N. My address is 9 Price Lane in Smithfield. I do. Good evening. I have some very simple, brief comments. It's not heavy duty like we've heard already, so you can relax your mind here. I just want to do a quick follow-up on a previous presenter here who talked about noise. with a lot of detail. I just wanted to suggest that I've reviewed all the documents submitted by the applicant, and I have not seen a noise study prepared by them and submitted to the board. If it has, I haven't seen it in the public realm. So I just wanted to make that comment. I am opposed to this high-density residential development. As you know, I've already submitted 2 documents for your review. One for the December 10th planning board meeting and one for tonight's meeting, including an emailed version so you could see the pictures clearly and view the videos I felt were very relevant for this proposed development. I detailed 3 areas of concern for the development. 1, airport hazard zones safety concerns. 2, Line Rock Road safety concerns. And 3, overdevelopment and the loss of rural character. I presented all the pertinent details in those documents, and I won't talk about them, about the content that tonight. I want to just briefly comment about the many people who have made their voices known about this project. There is overwhelming opposition to this high-density residential development, including the following: many state and local elected officials, the hundreds of concerned residents, neighbors, and abutters who filled this auditorium on October 23rd, on December 10th, and tonight, and those watching these meetings via live stream. All the neighbors and abutters who spoke into this microphone and voiced their very legitimate and valid concerns. And the many people who display a very visible sign in opposition to this major condo project, including neighbors and businesses on Lime Rock Road, Blackbird Farm, the Orchard Meadows condos, the abutters like the Buddhist Temple, and my many neighbors throughout Highview Hilldale Estates, directly across from Lime Rock Road from this proposed development. You have been provided with competent and compelling evidence to make a thoughtful and well-informed decision about this matter. Whenever you are ready to take your vote, I respectfully ask you to vote to deny this comprehensive permit application. Thank you for taking the time to review my submitted documents, for listening to all the public comments opposing this development, and for thinking about Smithfield's future residents, like those who would live in this proposed development, and whose very health and safety would be at risk. Thank you.
Thank you.
Hi, how are you? Eric Correa, 5 Deer Hill Drive, Smithfield.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do. Correia. My father-in-law, he can't be present tonight because my mother-in-law is very ill. But he wrote this out, you know, and he'd like to say a few things. And he's observed and calculated after living off Lime Rock Road for 45 years. It's obvious that the use of Lime Rock Road has increased over the years, as it was determined that traffic light is now age end, which when he moved here obviously was not. He also realizes it's difficult to patrol and control the speed on a 2-lane road with no side lanes and the telephone poles less than 2 feet off the blacktop. Lime Rock's also become a shortcut for traffic from 295, 123, vice versa, including trucking. And as far as the existing residents that use Lime Rock, they come and go multiple times a day. Not to mention all the commercial businesses are located right off Douglas Pike. Okay, they're gonna come down. You have Gem Plumbing, you have so many different companies that utilize that road. It's across. Even myself, I had an appointment in Pawtucket the other day. You don't get on the highway. You go through Whipple, you go around, you go through the back, you go down, and it's constant for residents, non-residents. You know, at least 2 cars just once a day, which is really not normal. Okay, the traffic studies are really based on minimal numbers. You know, with the neighbors, as far as what's gonna happen is there's gonna be more harm than good, and many people have already said that. You know, there's just not enough room there. You're trying to put 5 pounds of shit in a 10-pound bag, right in reverse, okay? Not counting the daily traffic, which is constant. The point is, adding another 112 more residents creates 220 cars or so,
not counting those who cut through. Now, there's children on bikes, et cetera. We're not talking about just the corner of Douglas, okay? You're talking about a neighborhood that abuts that with kids that are playing, and already people cut through there now. So just put all these people over there, okay? And they're already trying to build up commercially up the road. You know, there's enough, okay? Now, I lived in Johnston, okay? I had a beautiful house in Johnston. I worked my ass off to come to Smithfield, okay? And currently, you know, I'm in a small town, and we're trying to build every single square inch of this place based off. Every week, I have a note to look at the town website to see what's on the agenda next. This isn't even right next to my house. It's next to my father-in-law's house. But I'm down the road. I'm gonna come off 295. I'm gonna come up the other way. I'm still gonna have to deal with that traffic. And sometimes you get off 295 and you see up the hill, all the way up to Whipple, a line of red lights. So how is this in any way gonna help anybody? Not to mention, how soon is it gonna be before somebody gets hit by a car over there? I mean, that's just ridiculous. They'll help with the sewage and all that. They'll help. Okay, I wanna see that it's all ready to go. Okay? Obviously, the planes, et cetera, that's just ridiculous. You can't drive that road without the two hands on the wheel. I kind of got off topic from what my father-in-law said, but it's in closing, we'd hate to have to point out that we already know what the situation is. And when he came here 45 years ago, they paid more for the plots, okay, for zoning with larger lot sizes, but for a reason. To keep as many places out. That's 45 years ago. So now that's like, what he did 45 years ago doesn't matter. Yeah, we're just gonna bury him. And you look at every single off-ramp, Johnston, condos, keep them there, okay? This is a town of Smithfield, not the city of Smithfield. As far as the rest is concerned, you know, experts are under oath, but it's under oath, and they're telling the truth as far as they're concerned. That's my opinion. We've had numerous small plane crashes that people have said, okay, the lighting, okay, we got light poles 6 feet high. He said, I'm 6'2", so I guess if I'm walking around, I can only look down. Okay, so I don't know how that's gonna work. What else? You know, there's a kid back there. He's got a spotlight. He decides to mess with the planes. Boom. You don't take that into account. As far as a successful landing zone, there's nothing for that. And all I see is come learn and fly a plane here. Learn how to fly. Let's do that. You know what? The first time I go try that, I'm gonna ask him to avoid that area with the houses. That's just my opinion. Take me to a big open field. That would be much better. Okay? That's what it is now, and that's what it should stay. As far as the expert, he doesn't know the facts about the project. He didn't study everything. That's pretty bad. He gets at. The number of affordable housing units doesn't do anything to help the housing prices. The developers are using the law as a loophole to shoehorn their full price units in. None of this is being done for the community's best interest. And their asshat attorney and shop dressed investors over there show just that. Thank you.
Nancy Lancaster. 22 Lori Ellen Drive, Smithfield, Rhode Island. I do. It doesn't seem all that long ago that I drove out of Park Road from my home, and I saw these white pipes sticking out of the ground. And I said, "Jeepers, that looks like perk pipes for a development." So I put a call out to many of the people in this room who are neighbors. And I said, you know what? I think we got a development going up on Lime Rock Road. Open invitation to come to my home, no drinks, but they came anyway. And it was that group that kicked off the following months of work. It wasn't all too many months ago that Mr. Cagney and Lanny came and sat with me in my living room after Jackie Moorhead bless her soul, put my name in every article in the Observer, and I couldn't thank her enough for giving us the coverage that we wanted. We've come a long way, and I have learned a lot. I'm a registered nurse, retired. This is way out of my comfort zone. But I stuck with it, and I think we have news coverage pretty much daily now that talks and demonstrates the divisiveness of our country. But look at this audience and the other audiences that we've had. That's not divisiveness. That is cohesiveness. They chose to come here, to be heard, to participate. And in addition, I gave you months ago a petition with many of these names on it, almost 400 names of people that were objecting to this development. And they're not just from Smithfield. We've had Burrowville, Situate, North Smithfield, Johnston. So goes these small towns as they watch your decision on this development. It's almost a watershed moment. And I think we should recognize that and stand very proud when we make our decision to deny this application. I'd like to summarize the major points that we've talked about over these many months. All of these comments that I will be making have been derived from the materials submitted by the developers, by transcripts from these meetings, and the actual comments from individuals that stood up and spoke. Number one, these homes are very small with very little storage space. All homes are identical with no options for any external changes for either appearance or, most importantly, functionality. Properties are very small with little or no options for outdoor play equipment. That was emphasized. No designated open space for children to play. The comprehensive plan requests that a rural character of the town be maintained, which provides for open space. School children requiring bus transportation must walk to buses unless, this was mentioned previously, little known fact that we found out, unless all residents of this development agree to sign in writing that they will allow the buses to come in the development. Which means, of course, that kids will be walking to Lime Rock Road and the buses will stop while children get on and get off the bus. Tick one more obstacle on Lime Rock Road. There are only one-car garages with no additional parking. That's pretty limited. All homes have been built on slabs, which indicates water and flooding risks, which have been very well documented and observed by we neighbors of the Lime Rock Road developments for years. Wetlands and rivers are numerous in this property, creating additional hazards. Clear cutting of trees was already noted in their submitted materials, which is going to contribute to more flooding. Flooding is evident not only in this entire parcel of land, but on the access road, Lime Rock Road. That's a treacherous running body of water and puddles. Alteration in the buffers for wetlands were changed to allow for LMI development. Lime Rock Road is a state road with jurisdiction only by the state. Changes to the structures to widen it or add sidewalks aren't going to happen. There is no safe walkable access, a requirement of an LMI development. So private transportation is essential. Travel times for residents has reached far greater weight, with over additional homes could impact work-life management.
leaving earlier to go to work, coming home later. It would be expected that alternate travel routes has been mentioned as they cut through the Lime Rock Road neighborhoods, Highview and Philby. Protection of the town's natural resources is not accomplished with this densely populated development. Trees will be leveled. Shrubbery along the side of the road, they've already identified, had to be cut back a very large amount to facilitate safe passage. Traffic studies confirm we got a bunch of speeders going through this town. So the road dimensions are minimal and risky. Our schools are overcrowded. I think Ms. Solda is still here. And she noted early on that the revenue is not equivalent to the expenses. The Church of God of Providence, who resides at 786 Elmwood Avenue, which currently owns this property, has not paid property taxes since 2011. Therefore, for Smithfield, no loss in taxes if this property remains open space. North Central Airport has been talked about just beautifully tonight. I think we have some audience members that would classify themselves as experts without saying so. The noise level has been talked about. I can tell you that conversations on my deck in the summer with the gin and tonic get halted as the flame goes overhead. The temple, who have been our lovely neighbors, we have lived peacefully in coexistence with them for over 30 years. Their reflective and meditational qualities of their faith is threatened with this development. The boundaries for building so close to their temple were disregarded because of the LMI mandates. So thank you, gentlemen, for recognizing the critical impact of this development by holding these meetings here in this high school, because I think you recognized we were going to have a good crowd, and we sure did. Also, volunteering your time as members of the board and taking this position. Please deny this application. I appreciate it. Oh.
Any other member of the public that would like to be heard before we close the public comment section? Not hearing anyone respond. Public comment is closed at 9:12. Mr. Resnick, do you care to either you or your team address any questions or concerns made by residents?
No, we're going to rely on our testimony in chief and the answers that we provided to the board. The only comment that I have, Mr. Chairman, is there has been a lot of discussion this evening about federal regulations, about Form 77 and associated approvals and permits from the feds regarding satisfying those requirements. I just want to remind the board that this is a master plan. And there have been projects before you previously where Form 77 elevation certificates and associated approvals were required. They are not required to preliminary approval. As you know, it used to be that you needed any and all federal and state approvals before you started the preliminary process. It's now that you just need the applications in, some comments back, and obviously you need to get the approvals before you would obtain a preliminary approval. So my suggestion is that because we heard the concerns of the community, the concerns of the board, we certainly presented on those topics. That doesn't mean that there would not be additional presentation, additional testimony at a preliminary stage. as you know, I mean, for instance, issues were raised about noise. Now, mitigation of noise is really an engineering discipline. And that is certainly something that would be considered and presented at a preliminary. Just in the same way that we're not going to do a presentation on stormwater and you're not going to do a peer review on stormwater at a master plan stage. So we played into the request of the board and the community to present this information at a master plan. But I just want the board to be aware, and as you know, and I know you, this is a three-part process. If we were to obtain a master plan this evening or at some other hearing date, it's not a guarantee that this project gets built. A master plan is never a guarantee that a project gets built. It is a guarantee that you can come back at preliminary and demonstrate through sound engineering in various disciplines, from aviation to sound to stormwater and the like, that you can build the project in a safe manner. And it's only at that time that you have a viable project that can be built. So I just asked the board to consider that, what we presented. And certainly, we would plan on presenting more at a preliminary because we're not at the conceptual stage. We would now be at a hard engineering stage. So I brought an engineer to provide opinions at a conceptual stage. We have Mr. Casali that has provided engineering testimony at a conceptual stage. Mr. Casali has not been asked to opine on stormwater issues because it's not appropriate yet. It's at preliminary. So I'm just suggesting that we believe that we've hit all the items, we've made our showing, that this is a viable master plan that should be approved, but that approval doesn't mean that this project gets built. It means that we have the opportunity to try to get any and all federal, state permits and sign-offs that we need and prove to you at preliminary that we can do this in a safe way.
We're mindful of what the application is,
Yeah.
and what the standard is.
Yeah, and I just know that there is a reason that the law was changed to restore to a developer in the comp permit a master plan. It was so a conceptual approval could be obtained before exorbitant sums of money were spent on hard engineering. So are we in a position to prove, as we would at a preliminary, that as it relates to all of these disciplines and all of the checklist items, that this can be built soundly from an engineering perspective? No, no master plan ever is. That's not what is required. Thank you, thank you. One simple thing. I would just ask if there are no further questions, we would request a vote this evening. Obviously, Mr. Chairman, that's within your purview and the board. Okay.
You guys want to take 5 minutes? Take any motion for discussion? Or do you want to push through? Push through? Any discussion?
For so much. Covers just about everything that the board needs to consider to satisfy the attorney's request. I have, there's been discussions about federal regulations, guidebooks, and other things that towns, cities and towns and governments are supposed to consider when dealing with powered human flight, which has been in development for 123 years. And I must say that the federal government has taken an interest in this remarkable achievement of humankind that 100 years ago this year, they passed their first legislation regulating the use of this technology. And in the ensuing decades, additional guidance and regulation has grown up as the urbanization of America has taken place. To the days of airfields in the middle of cornfields or rural areas is a thing of the past, when our population centers have grown more concentrated in urban areas. So I just don't like the way that that particular issue has been kind of tossed aside. And I think it should be considered in the discussion of this board and taken into serious consideration. Like you said, we're not relying on any kind of existing overlay. We're dealing with health, safety, welfare of the citizens of this town now and in the future.
Thank you, Mr. Long. Any other members? Any comment? Do we have a motion?
Yes, we do, Mr. Chairman. Upon review and consideration of the application, submission of evidence, and the collective testimony of lay, expert witnesses, and the general public, I make a motion based on legally competent evidence to deny the master plan application for the comprehensive permit as applied for the collection at Lime Rock Acres. And in support of denying the master plan, I make the following findings and disclosures of the nature and character of the observations upon this action. In considering the collection at Lime Rock Acres comprehensive permit master plan application, the board finds: 1, the proposed development is not consistent with the local needs as identified in the community's affordable housing plan as found in the Smithfield's comprehensive community plan, and has not satisfactorily addressed the issue where there are inconsistencies. The project is inconsistent with local needs as identified in the community's affordable housing plan and does not satisfactorily address inconsistencies as follows. Goal H-1, the project does not promote a safe, healthy, and high-quality housing stock through new construction and renovations of existing structures. As this project is sited within United States Federal Aviation Plot 77 safety surfaces, these areas include zones A, protection, B, critical approach and departure, C, transitional surfaces, and D, horizontal surfaces, of which in A and B zones, high-density residential development should be precluded. The density of this development within proximity to these zones is such that this project is a highly serious safety concern of the town of Smithfield, Rhode Island. This project's location in the airport hazard areas, zone A and B, when compared to the surrounding residential developments, is closer to the airport runway protection zone. In fact, this board reviews each project on its own facts to find that adding 3 times the units closer to the airport's RPZ portends significant negative impacts on the health and safety of current and future residents of the community. Policy H-3.1, the project does not integrate well into existing neighborhoods nor enhance quality of life. This finding is from the plans provided with the application, knowledge of the surrounding areas, and the existing development that has followed comprehensive plan and zone. The collection of Lime Rock Acres is not designed, nor is it similar to the surrounding neighborhood along Lime Rock Road. The project also surpasses existing condominium developments at Lime Rock Road and Douglas Pike in relation to the number of units, its massing and density. It far exceeds in size and is dissimilar to any of the above condominiums and townhouse styles in the area. The project would exist next to the airport and have to deal with noise and sound quality from planes immediately above the development. The project does not preserve the natural, historic, or cultural features that contribute to the attractiveness of the community through conservation. Goal H-4, the project does not relate the location, density, and nature of new housing the town's long-range land use and growth management policy. This board recognizes that affordable housing element goal H-4 incorporates other parts of the community comprehensive plan by mentioning growth policy. Yet under the new standards, this board cannot consider other parts of the community comprehensive plan. However, our affordable housing plan mentions growth policy. Therefore, this board needs to at least continue to consider the town in general with all projects before it. In doing so, this board needs to generally consider balancing elements of facilities, services, and schools, and this project. With this density in this area, it does not assist in managing growth as presented with the number of units, the increased demands to facilities, and the yet unresolved sewer capacity. When the board finds the proposed development is inconsistent with the community's affordable housing plan and has not addressed inconsistencies, it must also find the municipality has made significant progress in implementing the housing plan. This board must then consider whether this town is making significant progress towards affordable housing. In support of this element, in the past year, this board has approved projects with 53 of the 70 units being low, moderate income housing, which is about 75%. This board also, in October 2025, approved a project in Greenville with 100% affordable housing and approved at master plan the residents at 295, which will have 25% LMI. This is significant progress. This board's record shows a clear absence of unreasonable denials of comprehensive permits. 2, the proposed development is not in compliance with the standard and provision of the municipality zoning ordinance and subdivision regulation, and/or where adjustments are requested by the applicant. Local concerns that have been affected by relief granted to outweigh the state and local need for low and moderate income housing. Generally, this project does not meet for the density proposed. Generally, this project does not meet zoning for the density proposed, but the board recognizes that under a comprehensive permit, allowances for density in zoning and other variances are allowed. However, under our zoning ordinance, Article 12, Comprehensive Permit Section 12.5.31, General Condition. Properties meeting the following general conditions are determined by the planning board shall be eligible for consideration as low moderate income housing, LMI project. 1, property shall be located in or within close proximity to one of the town's existing population centers. 2, accessible to major transportation and transit route. 3, proximal to community service and amenities. This project is not. The board is familiar with this area, and based on the documents and testimony, there is not any major transportation or transit for this project available. The residents will have to walk Lime Rock Road, which does not have any sidewalks, and then walk Route 7 to get to a bus stop. There is not a population close by, and services and amenities are not easily accessible without a vehicle. The testimony by the applicant's land use expert is not accepted when contemplating the elements of whether this project is truly accessible and accessible in a safe manner. 3, the LMI housing units proposed are integrated throughout the development, are compatible in scale, and are compatible in scale, are of similar architecture and style to the market rate units within the project, and built and occupied in a professional manner with consideration and occupancy of the market rates. The evidence established that this element can be satisfied. 4, whether there will be significant negative impacts on the health and safety of current or future residents of the community in areas including, but not limited to, safe circulation of pedestrian and vehicular traffic, provision of emergency services, sewage disposal, availability of potable water, adequate surface runoff, and the preservation of natural, historical, or cultural features. This project does not meet this element. The applicant's testimony regarding this site clearly established that the project will be built in FAA Part 77 approach surfaces, including hazard areas A, B, C, and D, of which hazard areas A and B are of particular concern under FAA airport planning guidance. In addition, this development proposes passive open space for residents within Zone A. Zone A is a runway approach zone. In this review, this board has learned through testimony, narrative submission at page 8, section 2.9, and testimony on this topic that these hazard areas are not designated for high-density development, and such development should be limited to a consideration of low density, if not altogether precluding. The board has significant concerns for the health, safety, and well-being of residents to allow such high-density development to take place in hazard areas that do not indicate promotion of such density, and that 90% of the proposed project is in hazard areas A and B. There is a significant concern for safety. If a plane does crash in a high-density development, basically abutting the airport, the impact to the number of residences, the impact to town services to respond, given the density that could be strained, and the overall subsequent impact to residents from hazardous events. The board finds that the testimony on this element by the applicant's expert that high-density development at this property in the hazard areas is safe is not accepted and was satisfactorily impeached or questioned. Also under this standard, sewer capacity is a consideration. The Whipple Road Pump Station is operating near its rated capacity and may exceed the threshold under full build-out condition. The testimony has not satisfactorily explained how this will be resolved. Third, the evidence is that there is not safe circulation. The development does not propose sidewalks along internal private streets or along Lime Rock Road. It proposes 6 additional access points onto Lime Rock Road, 3 roads at high-activity intersections, and 3 private drives. Several units are 4-bedroom homes likely to house families with children, yet no safe pedestrian facilities or designated outdoor play areas are provided within the neighborhoods. This omission could adversely affect safe pedestrian circulation and family health and safety, as also described under our Article 12, Item 3.4. The evidence is that aside from statutory wetland and buffer protections, the project has not proposed preservation of substantial natural open space or other cultural historic resources on site. The historic view shed along Lime Rock Road is segmented or erased. The absence of designated conservation areas limits opportunities to maintain natural character within the development. In addition, there are prime state agricultural soils present within the development. This project neither preserves the natural nor the historical or cultural features that contribute to the attractiveness of this community. 5, whether the proposed land development or subdivision lot will have adequate and permanent physical access to public streets according to the requirements of Section 4523-60A5, or this board has approved other access. The evidence established that this development proposes 6 separate access points, and this element can be satisfied. 6, whether the proposed development will result in the creation of individual lots with any physical constraints to development, that building on these lots according to permanent regulations and building standards would be impractical unless created only as a permanent open space or permanently reserved for a public purpose on the approved recorded plans. Though there was testimony by the property's previous owner that there are large areas of wet soil within the site, the evidence established that this element can be satisfied. That is the conclusion of my motion, Mr. Chairman.
Do we have a second? All in favor? Aye. All not in favor? The ayes have it.
Mr. Chairman,
Excuse me. If I may.
Yes, Mr. Rosette.
Mr. Chairman, thank you for everybody's time this evening. We certainly respect the decision of the board discussing with my client's next steps. I would like to ask one question. Obviously, it's up to the chair whether there be an answer provided. This evening, as you know, we continued this matter to a public hearing. And we came here this evening, and we came here with two experts. And actually, you brought in your own expert, a peer review expert. It seems that Mr. Moan, in reading the motion, was reading from a pre-prepared document. I'm not aware that anybody was drafting anything while this hearing was going on, and I would just simply ask this. When was that document created? Was it created before we took the stage this evening for this open public hearing to present additional testimony? I would just like to know when it was generated.
I don't know when it was generated. I don't know what exactly form as he was giving his decision. The board has ruled. Thank you for your.
And I just have one final inquiry. Mr. Chairman, would you be amenable to canvassing the board members to determine whether any of the board members saw this draft or discussed this draft by amongst yourself or with Mr. Moan before it was voted this evening? I was surprised that such a structured decision was created and determined tonight when we just closed the public record.
Yeah, no, that's not our procedure on the board.
All right, I'll submit an APA request. Thank you.
We have a motion to adjourn.
Motion to adjourn.
Second? Do we have a second?